The Judiciary Committee will come to order. Without objection, the Chair is authorized to declare recesses of the committee at any time. We welcome everyone to today's hearing on executive privilege and congressional oversight. I will now recognize myself for an opening statement. For more than 200 years, Congress has exercised its power under Article 1 of the Constitution to conduct oversight of the executive branch. Congress' power of inquiry, recognized by the Supreme Court in case after case for nearly a century, is essential to our constitutional order. Without it, Congress would have no way to expose waste or misconduct, to inform itself for purposes of writing new legislation, or to ensure that public officials, including the President, remain accountable to the people they are supposed to serve. Congress and the executive branch have fought over requests for information in the past. At times, this has included disagreement over the scope of executive privilege. The doctrine that holds that certain information may be withheld from Congress under limited circumstances to protect the President's ability to seek candid advice from his or her advisors. But while the courts have held that the President's communications are entitled to some degree of confidentiality, they have consistently held that the privilege is not an absolute shield and can be overcome when the interests of justice require it. Until recently, no president had ever stated that his plan, across the board, would be to fight any and all oversight from Congress. In declaring that he plans to, quote, fight all the subpoenas, unquote, President Trump has announced his hostility to our system of checks and balances and is thereby seeking to hold himself above the law. The President's statement was not just isolated rhetoric. It was an admission of what this administration has been doing and has recently escalated since the start of the 116th Congress, when it became clear that the House of Representatives would carry out its duty and the will of the voters by engaging in constitutionally necessary oversight of the executive branch. By this administration's command, the White House has attempted to impede over 20 congressional investigations, including by ignoring or failing to provide meaningful responses to dozens of letters requesting information on topics ranging from the Affordable Care Act to the security of our elections to the policy of separating children from their parents at the border. Government witnesses have failed to appear for hearings and interviews. While in other administrations, Congress issued subpoenas only as a last resort when negotiations failed, the Trump administration has often been unwilling to engage with Congress at all unless and until a subpoena is issued and a contempt proceeding is looming. This constitutional brinksmanship is particularly unacceptable where, as here, the President is using the powers of his office to impede an investigation into his own alleged misconduct. For months, this committee and others have made clear our expectation that the Department of Justice must produce an unredacted version of Special Counsel Mueller's report, as well as the evidence and other investigatory materials underlying the report. We wrote to Attorney General Barr about this in February. We repeated that request multiple times throughout the months of March and April. The committee's contempt report describes these exchanges in exhaustive detail. On April 18th, having received no substantive response from Attorney General Barr, the committee issued a subpoena for the unredacted Mueller report and the underlying materials. This is information to which we are constitutionally entitled and which we need to fulfill our legislative and oversight duties, including to protect the integrity of our nation's elections. Yet it was only in the days and hours leading up to this committee's markup of the contempt report that the Justice Department engaged in negotiations. Even then, the department's quote-unquote accommodation efforts were wholly insufficient. I put that in quotes because I wouldn't even call them real accommodation efforts. The department was willing only to discuss severely restrictive terms on which a small number of members could review some of the redacted portions of the Mueller report. It remained unwilling to make any substantive offers to produce any underlying evidence or investigative files. Then at 10 p.m. on the night before the contempt markup, the department informed us that it was ending those negotiations and would request that President Trump assert executive privilege as to the redacted portions of the Mueller report and for each and every underlying document subject to the committee's subpoena. The President's protective assertion of executive privilege is unprecedented in its scope. The Justice Department openly admits that it has not even reviewed all the underlying documents, let alone provided any specific reasons for withholding them. Although the Attorney General has cited one example from the Clinton era in which the President made a protective assertion of privilege to allow more time to review the requested materials, in that instance, the White House had already been providing documents to Congress on a rolling basis for nearly a year, and the White House completed its review just 15 days later. This administration has produced none of the evidence underlying the Mueller report, and it has made no effort to show that it is now reviewing these documents on a good faith basis to determine which ones, if any, are legitimately subject to privilege. In any event, as the committee has pointed out in multiple letters to the Attorney General, the White House has already waived executive privilege several times over, to the extent it ever could have applied to underlying evidence collected by the Special Counsel's office. Moreover, no court has ever held that the executive branch can withhold documents from Congress in the face of a subpoena simply because they consist of law enforcement files. Congress routinely receives this type of information. In just the last Congress, the Justice Department produced hundreds of thousands of pages of sensitive law enforcement files in response to congressional subpoenas, including files pertaining to the Russia investigation, which was ongoing at the time. For these and other reasons, I am deeply troubled by the President's 11th-hour decision to make a blanket invocation of executive privilege for all redacted portions of the Mueller report and all of the underlying materials. I had invited White House counsel Pat Cipollone to testify at today's hearing so that he could better explain and defend the White House's assertion of privilege. But he has declined that invitation, and he has instead submitted a written statement that restates the same arguments previously raised by the Justice Department. I ask unanimous consent to enter this letter into the record. Without objection, it will be entered. I also ask unanimous consent to enter a letter I sent to the White House on May 10th, 2019, also on the topic of executive privilege. Again, without objection. This letter sets out a more detailed description of our negotiations with the Department of Justice prior to its 11th-hour invocation of executive privilege. Fortunately, today's witnesses have a wealth of experience and expertise on matters of executive privilege, including from the Justice Department, the White House Counsel's Office, and even the Office of former independent counsel Kenneth Starr. Although these issues about privilege and document requests may appear technical, what they ultimately come down to is whether the President can shield himself from accountability to a co-equal branch of government. I look forward to today's discussion of these important matters, which lie at the core of our nation's commitment to the basic principle that no man or woman is above the law. It is now my pleasure to recognize the ranking member of the Judiciary Committee, the gentleman from Georgia, Mr. Collins, for his opening statement.
Thank you, Mr. Chairman. And I think, as we will see today, welcome to a redo of something that probably should have happened a long time ago. A deliberative body like the Judiciary Committee commands respect, but only when it conducts itself in a respectable manner. And what we've seen in the last 5 months is their actions have put our influence at risk. In fact, no one on our side, and it's sort of crazy, no one on our side is questioning oversight ability of Congress. I have said it many times when we're in the majority and I have in the minority. Oversight of Congress is a powerful tool and should be used. Article 2 is many times what I have found is members of Congress before I got here, he gave up a lot of our, the authority that we have in Article 1 to Article 2, and that's a problem. However, you use it in the right way. Oversight power is properly done as a powerful tool, but when it is not done, it actually weakens us. When you actually, as the chairman talked about subpoena power, you actually threaten the acting attorney general at the time with a subpoena and then had to back off. A subpoena was not used as a last resort. It was used as a threat and then backed off of. This is what we've seen so far in this Congress. We've talked about it last week. One of the reasons I believe we're having this hearing today is to come to talk about executive privilege and to talk about these things is because last week we showed in the contempt hearing that the majority actually did ask for 6E information. Actually asked for 6E information, which they cannot have without going to court. It's in the subpoena, and there's not a law professor sitting in front of me that wouldn't agree that the four corners of a subpoena is what the judge acts on, not the intent of the majority. So when we do this, we continue to downplay the role of this committee. Many of us were lawyers before we became politicians, and I was actually a lawyer and a pastor beforehand, beloved professions in which reason matters, in which pride, when we come before us today in this matter, I'm glad that you're all here. I appreciate your backgrounds and your opinions, and we're going to hear this today. But again, I think we've come after the fact. We're now trying to go back and lay groundwork for what they may want to do later when this could have been done beforehand. We said this last week. You know, it is often said, and the chairman just said, that the Congress is a co-equal branch. I actually think it is the premier branch because we're the ones that actually start the money. We're the ones that actually have control. We're the closest to the people. We're the ones that have enormous power. And the president does answer to Congress. And with all its power to enact laws in enormous breadth, this committee's authority to remove a president and upending the entire election, that is the majority, has chosen to focus on. That's it. For the past month, the Democrats have focused on the few areas in which we are not given boundless prerogative. We know the danger of simple majority rule. We're not a country run by a 51% majority. Without a division of centralized power, democracy becomes anarchy, and so the Supreme Court has power. The Attorney General has power, and even if he's not a member of your party, the President has power, which we recognized when Mr. Obama was in power. But for the past months, we have besmirched this body and failed to do our jobs. This committee is one of the most important bodies in Congress and has become a parody. With the results of the Mueller investigation did not satisfy the Democrats, they quickly started peddling to the American people the manufactured constitutional crisis. The majority turned a reasonable discussion of the Mueller report into an opening of cannon fire for the circus that they have created. And we're back at the circus again, and you've been brought into it. We have also looked at those who are channeling outrage for impeachment while then going on TV and saying we need to back off. It's a base perception political issue. We even have some that have actually, on the other side, become megaphone operators, roaring about evidence and nowhere to be found and demanding punitive action when they cry, "What's next?" Never mind the absurdity of what's next. For one example, the chairman claims that a subpoena is merely the beginning of a dialogue weeks after assuring our committee that a subpoena is a powerful and coercive tool and to be only used when our attempts to reach accommodation with the witnesses have been reached an impasse. That's what we actually heard last week. Not only is a subpoena the start of a dialogue, it's to give us better standing in court. Y'all, I mean, my law school didn't teach that. In fact, the judges that I went before actually believe the subpoena is a powerful tool, as the chairman said earlier this year. We're going very fast. You're here today to give cover. And they did so with no hearing, no groundwork when they held Mr. Barr in contempt. In fact, a mere 19 days had passed from the issuance of the subpoena and contempt. When the Oversight Committee had held Eric Holder in contempt, 255 days had passed, 13 times as fast. Now the Democrats tell us that they're taking the circus to court because the president has asserted executive privilege, a fact they claim represents a constitutional crisis. Today we'll discuss that debate and privilege. Many people claim Republicans on this committee are covering for the president when we should join the Democrats in their demand that the Attorney General violate the law, which is what the subpoena said. So instead of stripping our branch and our oversight authority, we actually believe that we have it. But I can't also let it pass because, Mr. Chairman, here we are again having this hearing, and again, I appreciate the witnesses coming and spending your time with us, but we have a crisis on our border. Even the New York Times, Washington Post, everybody else has talked about the crisis. We've not had anything about that. We've talked about DACA, but we've not talked about the crisis on the border. We have issues of intellectual property and trade on the front headlines of a deal with China. This is the Intellectual Property Committee. Have we done anything? No. We focused entirely on this one area. But the one that got me the most, frankly, as a son of a Georgia State Trooper, was This is Police Week. This is a time in which we honor our police officers and law enforcement in which they have come. 30,000 almost are in D.C. this week. And yesterday we had one bill on the floor. Bulletproof vest, great bill. I was a co-sponsor, original. One bill. In the past, we've averaged 9 to 10 addressing the issues and needs of our police officers. But what we did have from the chairman, and I asked unanimous consent that it be entered into the record, is a letter from the chairman and several of our members to General Barr wanting to talk about police-involved shootings and unarmed people in Ferguson, Baltimore, Cleveland, Chicago, Falcon Heights, Tulsa, Pittsburgh, and Dallas. And they list off statistics that in 2018, 992 people were shot and killed by police. No context, no thought about how many of those actually pulled a gun on an officer. No many of those actually were looking, unfortunately, at what we have seen as a phenomenon of suicide by cop. We just throw numbers out there. Well, I'm going to throw a couple other numbers. 144 officers died in the line of duty. This year, over 86 have died in the line of duty. When one of the police organizations heard about this letter, this was their reaction. Well, that's a slap in the face. It's tone deaf. We could have waited a week. Then had this, nobody would have said a word. But in the middle of Police Week, Mr. Chairman, with everything this committee has going on, we'll have this hearing. I'm glad our witness is here. I'm glad your witness is here. Because we're having to redo, get the cart before the horse again, trying to get it right for this one single-minded focus of hatred for a president and an attorney general. The oversight of this committee is unquestioned. We have oversight. We will work through that. But when we're hell-bent on finding an excuse to the point that we slap our officers in the face, I have no problem with looking into these issues. None at all. But when we put one bill on the floor and we send this to the Attorney General during Police Week, I don't think there's a person on the other side of this dais should say anything about supporting police this week. Just be quiet. Go on to the next week, and we'll get on to this letter then. And hopefully, Mr. Chairman, we'll take up something. As one of your members and I have talked on several occasions, maybe we'll get to some things that we can actually agree upon. I've got no problem disagreeing with the other side on policy. What I do have a problem with is we never get to it. We're back at the same thing again and again. So for the folks here and our witnesses, and for both sides of the dais, welcome back to the circus. Another week is here, and we'll pop the popcorn while we continue to rehash the past. With that, I yield back.
Thank you, Mr. Collins. I will now introduce today's witnesses. Professor Kate Shaw teaches law at Yeshiva University's Benjamin Cardozo School of Law. She received her Bachelor of Arts from Brown University and her JD from the Northwestern University Pritzker School of Law. Prior to joining Cardozo, Professor Shaw worked in the White House Counsel's Office under President Barack Obama as Special Assistant to the President and Associate Counsel to the President. Paul Rosenzweig is Senior Fellow for National Security and Cybersecurity at R Street Institute. He is also Professorial Lecturer in Law at George Washington University School of Law. He received his BA from Haverford College, his JD from the University of Chicago Law School. His prior professional experience includes working as Senior Counsel on independent counsel Ken Starr's investigation of President Bill Clinton. Jonathan Turley is the J.B. and Maurice C. Shapiro Professor of Public Interest Law at the George Washington University School of Law. He is a nationally recognized legal scholar and has written extensively in areas ranging from constitutional law to legal theory and tort law. Professor Turley received his BA from the University of Chicago and his JD from Northwestern University Pritzker School of Law. In 2008, he was given an honorary doctorate of law from John Marshall Law School for his contribution to civil liberties and the public interest. Neil Kinkhoff is a professor of law at Georgia State University College of Law. He graduated from Boston College with a BA and received his JD from Case Western Reserve University. Professor Kinkhoff's prior professional experience includes serving as Special Assistant to the Office of Legal Counsel at the Department of Justice under President Bill Clinton. During the Clinton impeachment proceedings in 1999, Professor Kinkhoff was a legal counselor to then-Senator Joe Biden. We welcome all of our distinguished witnesses, and we thank them for participating in today's hearing. Now, if you would please rise, I will begin by swearing you in, although I must confess that I always feel a little silly asking people to swear that they will tell us their opinions truthfully, but nonetheless, do you swear or affirm under penalty of perjury that the testimony you're about to give is true and correct to the best of your knowledge, information, and beliefs, so help you God? Thank you. Let the record show the witnesses answered in the affirmative. You may be seated. Please note that each of your written statements will be entered into the record in its entirety. Accordingly, I ask that you summarize your testimony in 5 minutes. To help you stay within that time, there's a timing light on your table. When the light switches from green to yellow, you have 1 minute to conclude your testimony. When the light turns red, it signals your 5 minutes have expired. Professor Shaw, you may begin.
Chairman Nadler, Ranking Member Collins, and distinguished members of the committee. Thank you for the opportunity to testify here today. As the chairman said, my name is Kate Shaw. I'm a professor of law at Cardozo in New York City, and before I began teaching, I spent several years as a lawyer in the White House counsel's office. I understand that the purpose of today's hearing is to contextualize and assess the White House's recent protective assertion of executive privilege over the entirety of the unredacted Mueller report and underlying materials, as well as the committee's ongoing exchanges with the White House regarding former White House counsel Don McGahn's documents and testimony. So in brief, my view as both a scholar and a former White House lawyer who does believe in a constitutionally grounded executive privilege is that blanket invocations of executive privilege of the sort the White House has made here are without substantial support in either case law or executive branch practice. Moreover, they are unsupported by the principles that underlie the privilege. My written testimony provides background on executive privilege, both generally and in the context of congressional oversight. So I'm not going to spend much time on that background. I'll just say that the judicial authority in this area is limited, both in volume and its utility. What I think is more significant here is the authority from the political branches. In particular, the numerous written opinions and directives from presidents and senior Department of Justice officials from both Republican and Democratic administrations that have guided the executive branch's approach to these issues for many years. I won't describe those documents in detail. Instead, I'll just say that they reflect a strong vision of executive privilege, an entitlement which the executive branch understands to have constitutional foundations to keep certain documents and communications confidential. But they also reflect a recognition of Congress's constitutional entitlement to access at least some executive branch information. So abiding by these principles, the executive branch has, in countless inquiries over the years, worked with Congress to grant some information access while protecting documents they believed in good faith could ultimately be subject to an assertion of executive privilege. That, I believe, distinguishes the executive branch's approach in these proceedings from longstanding principles and practices. The White House's broad protective assertion of privilege encompasses documents that could not possibly be subject to a claim of privilege. So let me elaborate on this, first in the context of the committee's request for the full unredacted Mueller report and underlying materials. First, the White House has not identified the particular strains of executive privilege that might attach to the materials at issue here. Executive privilege isn't a free-floating entitlement to conceal embarrassing or inconvenient information from public disclosure. It protects certain narrow categories of information for specific reasons, chief among them the importance of protecting confidential advice to the president. Some of the materials at issue may implicate that strain of executive privilege. Some may implicate other categories of executive privilege, but many appear likely to have, at best, shaky support in law and in practice. Second, as to those portions of the report that have already been publicly released, and potentially some of the underlying materials that are summarized and reflected in the Mueller report, the White House, by failing to object to public release, has clearly waived any plausible claim of privilege. Third, insofar as some of the documents contained within the set might contain evidence of misconduct, and even a cursory read of the Mueller report establishes that some very likely do, claims of executive privilege may be weakened or unavailable. That's because a number of courts have held that allegations of misconduct erode, if not vitiate, at least some forms of executive privilege. So if the documents at issue reveal misconduct, that should minimize the president's legitimate Article II interest in protecting them and increase congressional authority to obtain them. Fourth, there is some authority suggesting that in order to qualify for the privilege, at least the presidential communications privilege, right, this subset of executive privilege, the communications at issue must have some nexus to the performance of a presidential function and must be consistent with presidential duty. So the D.C. Circuit, echoing the Supreme Court's foundational executive privilege case, United States versus Nixon, has emphasized that the purpose of the presidential communications privilege is to ensure that the president receives full and frank advice with regard to non-delegable powers. And the key D.C. Circuit cases here involve the appointment and removal power and the pardon power, so these are key presidential powers. So documents that pertain to the exercise of those powers may well fall within the privilege. But as to documents that reflect the president engaged in very different kinds of conduct like potentially endeavoring to end an investigation for corrupt or self-interested reasons, those documents might not be eligible for the assertion of privilege at all. Briefly, as to the additional documents in the possession of former White House counsel Don McGahn, the White House has suggested that the documents sought by the committee implicate significant executive branch confidentiality interests and executive privilege, but to my knowledge has not moved to formally invoke executive privilege. For several reasons, the White House, I believe, lacks a strong foundation for an assertion of privilege here as well. First, the White House did not assert any privilege with respect to McGahn's provision of information to the special counsel's office, and more importantly, nor did it object to the release of the largely unredacted report. Now, This may not constitute a waiver as to all of the documents in Don McGahn's possession. But as to those materials that were incorporated into the now public report, I do not believe there remains any strong privilege claim. Second, the president has made numerous public statements, as recently as last week, to put before the public his version of conversations with former White House counsel Don McGahn. Although there's no direct judicial authority on the impact of such statements, there is some analogous authority, cases that prevent the executive from making self-serving statements, then retreating to privilege to prevent the disclosure of information that might undermine a one-sided account. And third, I see my time is expiring, but third, where there is evidence of misconduct, as with the materials underlying the Mueller report writ large, the argument against their disclosure is accordingly quite weakened. As to all of these, these are legitimate matters of congressional inquiry, and again, as to those potentially misconduct revealing documents, the White House does not have any strong legal basis to resist their disclosure. I'll end by saying a strong executive privilege and strong congressional oversight authority are both critically important principles. The sequence of events, as I understand them, suggests that the conduct of the White House poses a threat to both. With that, thank you, and I'll look forward to your questions.
Thank you very much, Professor Rosenzweig.
Chairman Nadler, Ranking Member Collins, members of the committee, I too thank you for the opportunity to appear today and testify on the issue of executive privilege and congressional oversight. I confess I'm somewhat surprised to be called today. As you know, Mr. Chairman, I've testified before the House and this committee on earlier occasions, almost always as an invited witness of the Republican members, and in at least one instance in substantive, but I hope polite disagreement with you on an issue related to the domain name system. Today, however, I come to speak about the rule of law and the virtue of its consistent application, a premise on which I hope we can all agree. In my written testimony today, I made a few points which I can summarize as follows. First, there is a long history of congressional oversight of the executive branch activity that dates back to the founding of the American public. I was delighted to hear, Congressman Collins, that you agree with Congress's investigative and oversight authority, because just yesterday, President Trump's attorneys argued to the contrary before the district court, suggesting that investigative authority was limited to the executive branch, an assertion that, in my judgment, is both wrong and almost ahistorical in its nature. Throughout our history, at least until recently, presidents have been circumspect in their assertion of a privilege to thwart congressional or criminal inquiry. Though views on the privilege have waxed and waned over time, throughout much of our nation's history, they have bent toward accommodation of legitimate investigative interests. Recent history sadly tells us a different tale, one of presidential invocations of privilege intended to conceal wrongful conduct or thwart legitimate congressional interests. I saw much of that firsthand during the investigation of President Clinton, an investigation that resulted in repeated invocations of privilege that were rejected almost uniformly by the courts. Much the same pattern of presidential resistance to oversight can be seen today. For me, the application of the same principles that guided the Clinton inquiry should guide this committee. Claims of executive privilege should be narrow, focused, and justified only by legitimate executive interest in fostering candid advice to the president. Broader invocations are ill-considered and ought to be rejected by this committee, by the courts to which these disputes might fall for adjudication, and by the American public. Indeed, it seems clear to me that the current broad-brush invocation of privilege advanced by the President stands on relatively weaker ground than that of President Clinton. President Clinton's invocations, unlike those at issue today, were exclusively focused on the core of the privilege, presidential communications. And Congress's interest in the current question of Russian electoral interference is surely of greater constitutional moment than the investigation of misconduct that surrounded President Clinton. In addition, President Clinton, unlike President Trump, did not seek to throw the cloak of privilege over documents that had already been disclosed to outside third parties, nor try and prevent private citizens from responding to a subpoena. And all of President Clinton's invocations occurred while he still faced potential criminal liability for his wrongdoing, a circumstance that, given Attorney General Barr's determination, no longer applies to this president. Finally, this particular invocation does not occur in a vacuum, nor is, in my judgment, this committee required to ignore the context in which it arises. By any measure, the President appears to have determined to resist almost all congressional inquiries through a variety of means, as yesterday's district court hearing demonstrates. This pattern is such that this committee may fairly evaluate the instant invocation against that background, which might be characterized as an attempt to avoid, or at a minimum, delay scrutiny of his conduct. For me, true adherence to the rule of law means that rules have to be applied even-handedly, regardless of whether a political party or other interest is immediately benefited. It means not invoking privileges to conceal wrongdoing, and it means not invoking them to frustrate legitimate congressional inquiry. That obligation, to be sure, falls on all citizens, but in my judgment, it falls even more strongly on the President, who takes an oath to uphold the law. Accordingly, if you continue to think that President Clinton's use of the privilege to avoid scrutiny of his actions was violative of his oath of office and deserving of condemnation, as I do, you can say no less about President Trump. As James Wilson, one of the founders and members of the first Supreme Court, put it, far from being above the laws, the President is amenable to them in his private character as a citizen. The framers of our Constitution rightly thought that presidents could and should be subject to congressional oversight, and the thoughtless invocation of privilege is in derogation of that high principle. I remain hopeful that in the end, the Department of Justice and the administration will recognize these principles and make reasonable accommodations to enable this committee to receive the information it needs while protecting the legitimate public interests embodied in the privilege. Thank you very much, Mr. Chairman.
Thank you, Chairman Nadler, Ranking Member Collins, members of the committee. Thank you again for the opportunity to appear before you to talk about a subject of such great importance as executive privilege and congressional oversight in the context of our current controversies. At the outset, I should repeat my well-known bias as a Madisonian scholar. I tend to favor the legislative branch. My default tends to be Article 1. My academic work has defended the authority of Congress for over 30 years. I've represented members of the House of Representatives individually, as well as the House of Representatives as a whole, in defense of what I consider to be inherent powers of this body that are being usurped by the expansion of executive power. It is for that reason that this is a curious position for me to be in. But I am not here, I haven't been called to give my personal view of executive privilege. I've always been a critic of executive privilege. I've been called to give my view of where the law stands now and how the courts are likely to view the current conflict. And on that, I offer a relatively mixed account as to the relative claims of this committee and that of the White House. The greatest concern I have, which I've put in my written testimony, is that this committee has an obligation, a sort of constitutional Hippocratic oath, to first do no harm. As an advocate of Article 1, the precedent that is used by this body in its very important work is not as deep or as broad as most of us would like it. It can easily be undermined with reckless litigation. For that reason, in my testimony, I've isolated what I consider to be the strongest and best ground for this committee to fight on, cases that I believe you would most certainly win. I've also identified areas that I've cautioned you not to pursue because the risks are too high. Now, the President has a right to assert executive privilege, and the Attorney General is obligated to defend it. But this committee has to pick its fights wisely. Bad cases make for bad law. So Congress has an undeniable and legitimate interest in this information. As I've said publicly, as I say in my testimony, I think the President would serve the public and his office best by waiving executive privilege over much of the documents used in the special counsel's report. But we have to address with what will happen once there is a challenge in court to examine that assertion. This body has decided to proceed as an oversight matter, not an impeachment matter. That will weigh heavily in any fights with the White House. The courts have indicated that on impeachment matters, there's a heavy deference that is given to this body. As a conventional oversight matter, it becomes more mixed. I've gone through 5 areas of information that's currently being withheld from this body. With some of those, I believe this committee will lose. On issues of the redactions, I believe this committee will lose. I think the case that the Attorney General has on those redactions is virtually unassailable. Where I believe this committee can win and where I think the White House is frankly unsupportable in its position, is to try to block witnesses from this committee. And ultimately, I believe that you will prevail on getting underlying material linked to the Mueller report. The question then is, how do you proceed? I've listed cases that give you an outline as to the most likely way to prevail, protect your precedent, and to move this along. Privilege fights are like invading Russia in winter. If you get into it, it's not going to be fast, and you're not going to get a warm reception in the courts. You have to be very careful of how you launch that campaign. In Paradise Lost, Milton referred to a Subornian bog where whole armies have sunk. Don't be one of those armies. If you attack Article 2 on weak grounds, you will sink in that bog. So what I encourage this committee in my testimony, which is probably too long, quite frankly, is that you focus on your strongest suit. Focus on forcing these witnesses before your committee. Focus on getting the underlying documents. Now, in that, you're going to have a mixed result on those forcing those documents to be released. What I say in my testimony is that the president has a valid executive privilege claim and this committee has a valid oversight claim. You're not going to win on a threshold fight. I also believe that it is not true that the president has waived executive privilege by showing material to special counsel. On that, I believe you will lose. And I strongly encourage you not to make that argument in federal court. The case law here is quite strong. That doesn't mean you're going to lose. It just means you're not going to have a takedown on the first round. Now, one of the things I also advocate for you to consider is that when you look at the redactions, I understand that you want to see the full report. The report has given you about 98% of it to select members. I understand that there's objections to how rigid those limitations are. That is not good ground to fight on. These other areas, I would bet on you. And those are the areas I would encourage you to focus on. Thank you very much.
Thank you, Professor Kinkoff.
Thank you, Chairman Nadler, Ranking Member, and more importantly, fellow Georgian, Mr. Collins. It's a real honor to be here today. This is an auspicious time for a hearing into executive privilege and congressional oversight, given the range of current disputes over executive privilege between Congress and the executive branch. These disputes involve a clash between constitutional interests. The Constitution vests Congress with an inherent power of inquiry. As the Supreme Court has stated, the scope of the power of inquiry is as penetrating and far-reaching as the potential power to enact and appropriate under the Constitution. The President also has a legitimate interest in confidentiality that's constitutionally rooted. The President's decision-making process requires that he be able to receive candid and robust advice from his advisors, and that advice, human nature tells, would be tempered if it couldn't be given in confidence. Neither of these constitutionally based interests overwhelms or trumps the other. Instead, they need to be balanced. And in the first instance, that balance is to be struck by the political branches themselves through a process of negotiation and accommodation. Attorney General William French Smith, who served under President Ronald Reagan, put it this way: the courts have referred to the obligation of each branch to accommodate the legitimate needs of the other. The accommodation required is not simply an exchange of concessions or a test of political strength. It is an obligation of each branch to make a principled effort to acknowledge and, if possible, to meet the legitimate needs of the other branch. This approach has been the standard model adhered to by administrations and Congresses of both political parties. It stands in stark contrast to President Trump's recent declaration of a blanket intention to oppose all the subpoenas. When privilege disputes have gone to court, the courts have repeatedly emphasized that the balancing of constitutional interests should not be done in the abstract, but instead should be done on a case-by-case basis that takes account of the concrete facts and circumstances presented by the particular issue. The subpoenas that this committee has issued involve an inquiry into Russian interference in our elections. In the concrete factual setting of these subpoenas, Congress's interest is of the highest constitutional order. First, Congress has authority to enact statutes to safeguard our elections from foreign interference. The sound exercise of that authority is fundamental to our democracy. And the threat to the integrity of our electoral system is not abstract or speculative. Russia has interfered in our elections, and according to our intelligence services, it will continue to do so. Second, the Constitution assigns Congress the primary role for addressing presidential misconduct. The Mueller report details exhaustive and voluminous evidence of presidential misconduct and of Russian attempts to interfere in the election. It details the president endeavoring to obstruct the investigation into Russian interference with the election. The report itself refrains from drawing a conclusion as to whether or not the president committed obstruction of justice in the sense of the federal statute. It refrains because of the special counsel's specific determination that he does not wish to preempt the political branches, Congress, from their primary role in addressing presidential misconduct. So Congress has overwhelming constitutional interests in receiving the material that it has subpoenaed in order to inform its judgment about safeguarding our elections and about how to respond to significant allegations of presidential misconduct. On the other side of the balance is the president's interest in confidentiality. The president has not, however, sought to specify within the factual setting of this particular dispute why it is that the discrete documents that he's withholding are within his authority to withhold. I won't go through all of the specificity that Professor Shaw, I think, so well covered, but I would say the balance of the interest, Congress's very weighty interest, and at least to this point, the president's only general and vague assertions, do not overcome Congress, and in the balance, Congress should prevail.
Thank you very much. I'll open up the questioning by recognizing myself first. Professor Turley, this committee issued a subpoena to former White House counsel Don McGahn for records provided to him by the White House in the course of his cooperation with the special counsel investigation. The current White House counsel, Pat Cipollone, has instructed him not to respond on the grounds that these records, quote, implicate significant executive branch confidentiality, interests, and executive privilege, unquote. Do you agree that those White House records are still legally protected from disclosure to Congress because they may implicate executive branch confidentiality interests?
Thank you, Mr. Chairman. It's a tough question. I'm going to give you a middle-of-the-road answer, if you don't mind. First of all, the problem with calling Don McGahn is, first of all, I think you have absolutely every right to call Don McGahn. The problem with the documents for McGahn is that his office sits at the very nucleus of presidential communication privilege. He's the really high-value witness for you to call in terms of the triggering of the constitutional fight. The material that he showed to the special counsel, in my view, is not waived, because that's a conversation occurring within the executive branch. It's actually even within the Justice Department.
That's my next question.
Yeah. I think the courts have already pretty much weighed in on that. I don't think they're going to view the documents that were not disclosed in the report as waived because it was shown to Mueller, because he is not an independent counsel, he's a special counsel.
And what about those shown to McGahn's attorney?
That I deal with in my testimony, and I say that's actually the most difficult question of all of these privilege fights. The courts are not clear whether if you show documents to an attorney, it waives executive privilege. And what I caution about in my testimony is I think that if you force this to a court, it's most likely that the court is going to find an accommodating rule. Because as I explained in my testimony, I can't thread this issue without having sort of rippling effects, not just on the executive branch, but on you and the legislative branch. For example, if members of Congress have an issue that could affect them personally and they speak to an attorney, does that waive congressional privileges? This is a very difficult question for a court to have to deal with, and I think it's likely the court will run home and say, you know what, as long as there's restrictions on confidentiality, like NDAs or non-disclosure agreements or agreements with the White House counsel staff, that I think a court is more likely to say there's no waiver.
Thank you. Professor Kinkoff, you testified that you thought we had the rights to these materials, as I interpreted what you said, the redacted materials of the highest constitutional order.
That's correct.
And that would disagree with what Professor Turley said. Now, do you agree with Professor Turley that in terms of obtaining these documents and other documents, we would have a much better odds in court if we were to label this an impeachment inquiry?
Well, I don't think the label matters, right? Because you have to decide whether or not to start an impeachment inquiry. And impeachment, particularly impeachment of the president, is a grave step. It's not one that should be taken recklessly. It would be irresponsible without first having information that the allegations of wrongdoing against the
Whether
president...
we should do it or not is a different question, but my question is, would it put us in a stronger position in court in arguing for a revelation of various materials?
I think it's enough that you say you're trying to decide whether or not to pursue impeachment. I don't think you have to actually invoke impeachment, and I don't think that the House has to actually form an impeachment committee.
Disagreement with Professor Turley and everything. Mr. Rosenzweig, when independent counsel Ken Starr transmitted his report to the House of Representatives, he also included 18 boxes of underlying evidence. Can you describe why Judge Starr thought it was important to provide that underlying evidence to Congress?
His view at the time, with which I agreed, was that that underlying information was essential to this body to perform the functions of its responsibility under Article I, namely to determine what, if anything, should happen thereafter with respect to President Clinton. There was obviously a slightly different context in the sense that that was a direct referral for impeachment purposes as opposed to purely for oversight purposes, but the fundamental thought that lay behind this was that it should not be incumbent upon this body to redo all of the work that he had done, nor should this body be forced to rely on his what he thought was good summary.
So in other words, you're saying it should not be incumbent on us now to redo all the work that Mr. Mueller did by analogy.
That would be my view as well. In pari materia, it's exactly what we said with respect to President Clinton. Yes.
Thank you. Finally, Professor Shaw, do you agree that do you agree with previous testimony on the question of waiver? That is to say, whether the White House waived executive privilege when it gave information either to Mueller or to McGahn's attorney?
I think I agree with Professor Turley that it's actually a quite difficult question. Certainly, all the public materials, any privilege has been waived as to those publicly released, the report itself.
By publicly released, you mean given to McGahn's attorney?
No, I mean, the redacted version of the report. No, the transmission to both McGahn and to his counsel, I think that the McGahn sharing with the special counsel is arguably an intra-executive transmission that does not necessarily waive privilege. That's all still within the executive branch. I would want to know, the White House counsel in his letter to you of May 7th, suggests that documents were, Mr. McGahn was there was a clear understanding that records remain subject to the control of the White House for all purposes. I would kind of want to know the circumstances in which that understanding was communicated. That seems to be sort of a sort of relevant factual question. I think as to the sharing of the documents with Mr. McGahn's outside counsel, there would be a close legal question. You know, the D.C. Circuit decision from 1997 sort of takes a mixed view of this. There's a little bit of waiver when there's sharing with a third party, but not waiver in any blanket sense. So I think it's close. I would agree with Professor Turley.
Thank you very much. My time has expired. The gentleman, the ranking member, Mr. Collins.
Thank you, Mr. Chairman. I want to go through several things, and I appreciate this is again, we were up here sort of talking about it. This is back in law school, and we have 4 law professors and 2.5 opinions. So it's pretty interesting to see how it's all went. And this is good. I mean, I like it. But I do have one just sort of a yes/no question, Ms. Rosa. Did you, when you worked with the Ken Starr investigation, was it not under a different, it was actually under a statute, correct? The independent counsel statute.
Ken Starr was authorized to investigate by the Independent Counsel Act.
Exactly. And Mr. Mueller was not, correct?
He was authorized by the special counsel regulations.
Which are different, correct?
Yes.
Okay, and they also have different reasons on what what they were to release and what they were not to release, correct? Yes.
I don't know. I'm not sure I agree with that.
Well, when one actually
the special counsel
one actually
regulations give Attorney General Barr plenary discretion to release whatever he feels is appropriate in the public interest. The special counsel regulations provide that Mr. Mueller's report is actually to Mr. Barr. So, in my judgment, at least, Attorney General Barr, in consultation with the White House, could release almost all of the reports, save for those portions that are prohibited by law from release.
Or in the reverse, he could release nothing and say this is what the Mueller report came out with, correct?
He could certainly have limited himself to a much lesser release if he had chosen to do so.
Okay, thank you. One quick thing, and I actually had this handed out to you, because this, I think what was said by several of you is the actual issue of congressional, and are we actually, and I understand the majority's desire to move this forward. I mean, I'm not denying the political aspect of this. But when you do, and I think Professor Turley and several of you have talked about the role and authority of Congress, which I do truly believe in, there is such a thing as moving too fast where you actually undercut your own authority. I've handed you the subpoena that was issued for General Barr. You have time to read it. You can talk about it if you want to take a second. Show me in here anywhere where there's an exception for 6E. There's not. I'll help you out. There's not. So to say that we're asking for something the Attorney General can do is not, and I understand the intent that was said from this dais. Well, the intent was that we'll go to court, we'll work it out together, sort of the Ken Starr a la model, which was a little bit different. But there's nothing in this subpoena right here that a judge would look at and say, no, you asked for 6E information, which he cannot do. It's illegal for him to do. You basically put, the constitutional crisis here would be to say, Attorney General, break the law because we want it. That's standing in the middle of the aisle and just jumping up and down and pitching a fit. This is what this subpoena is. Now, the question comes back, and by the way, GSU, I am so glad, go Dogs, but Mark Becker and y'all have done it. The Panthers are great and have amazing growth, and the law school is amazing down there, and it's good to have y'all here. But I think I just take a disagreement as we've looked at, as we go back through the issue, and especially where you said and Mr. Turley, I'm going to ask this question, but I want to acknowledge, is y'all both had disagreements. When he said that opening an inquiry, an impeachment inquiry, which, by the way, has not been said. The only issues that have been said from this committee are where there's an assault on the rule of law. That's more of an enforcement mechanism. That we're looking into election security. That we're concerned about overreach administration. We've never said, well, we're doing this specifically for impeachment. Mr. Turley, is it not true, though, the courts have ruled that if a judicial proceeding, would they consider an impeachment proceeding a judicial proceeding?
All right, that is true to the extent of some of the case law. This is where we differ. The Senate Select Committee versus Nixon in 1974 drew the distinction the chairman was referring to. In that case, Congress lost because it was proceeding under oversight authority. This body is actually playing the worst card in its hand. It has a very good card to play in terms of initiating an impeachment inquiry. But in that case, the court did draw the distinction that you asked my colleague about and actually said that it was determinative. I would simply encourage this: beware of close calls. This is not horseshoes and hand grenades. This body needs to litigate when it can be certain it can take down the executive branch. You have those issues. but beware of close calls, because that's where you lose precedent.
And just reclaim my time here for the last few minutes, because like I said, we'll go over this. I appreciate, the discussion. It's been interesting to hear already, and in the sense of, but it is an interesting issue when you have close calls, when you have, Professor Shaw, your discussion with Professor Turley just now. There are issues. My concern here is overriding, and this is my bigger concern. And you're here, in all fairness, to start a foundation for what was lacking last week and lacking in previous hearings, where we go straight to subpoena, straight to contempt, straight because we're so fast to get to the end of the day. But the concern that I have here is just expressed there, and some of you have actually expressed this, because we do agree in the sense. And Ms. Rosa, you said you've been here for Republicans. The reason you're here today is to prop up really a bad argument. And I appreciate you being here, and the others are here for that. And this is why we're here. But my concern is past the chairman and the ranking member. This body, look at the paintings on the wall. There's history here. This is beyond the moment of right now. And one day, the two of us will not be here. My friend from New York and myself will be back in Georgia and be back in New York, and there'll be other people in this chair. But if we have actually degraded the role of this committee by rushing to court, by rushing to conclusions, then we've actually taken the authority that we say that we're applying, and we've undercut it. And we've made it harder for future Congresses and future Judiciary committees to actually exercise their constitutional power. That's my concern with it. But it's good to hear y'all today. I'm glad you were having this discussion, I guess, as we go forward. And I appreciate the time, and with that, I yield back.
Gentleman yields back. The gentleman from Georgia.
Thank you, Mr. Chairman, and thank the witnesses for being here today. We're at a crucial juncture in our nation's history, and it's important that experts like yourselves help us clarify areas of the law that the administration and perhaps some of my friends on the other side of the aisle may be unclear about. We are in the early stages of a constitutional crisis. The flaunting of congressional subpoenas and the willful attempts to conceal information rightfully requested by the Congress shows an underlying disrespect for the co-equal branch of government that is the legislative branch. And it's imperative that Congress be allowed to continue its investigation into foreign interference in American elections. Special Counsel Mueller was appointed because of material concerns that the Russian government had inappropriately meddled in our presidential elections. After well over a year of careful fact-gathering and meticulous research, he and his team produced a 440-page report. And what did Congress get initially? A 4-page summary that included conclusions that Mueller did not find obstruction. Attorney General Barr essentially told us to move on, nothing to see. But that's not what the Mueller report said. We later learned that Mueller himself was concerned about misunderstandings about the report's contents that were perpetrated by the Attorney General. How can we trust when the Attorney General of the United States is prioritizing helping the president save face over the true facts of this matter? So we asked for the full report, and in response to our very valid request, the president claimed blanket executive privilege after the Attorney General stonewalled attempts to reach a reasonable accommodation. He just claimed a blanket executive privilege on the entire report and all of the underlying documents. Professor Shaw, what, if any, legitimate interests that the president may have, what if any, legitimate interest does the president have in protecting the confidentiality of White House communications or documents that may contain evidence of misconduct?
So where there's evidence of misconduct, Congressman, that any Article 2-based interest in protecting confidentiality is quite weakened. I would say that as a general matter, there may well be legitimate instances in which specific discrete documents in the possession of the special counsel would well be candidates for a viable privilege assertion. Some of the discussions between the president and advisors, even those that touch matters of the investigation. So, so long as they're not tainted by misconduct, presumably they were discussing how to respond to inquiries from the special counsel's office. And some of those discussions might well qualify as the kinds of considered deliberation between the president and his advisors that
Not a blanket.
establish. So all that, so all that I think would potentially qualify, but we don't know yet because they haven't given any specifics. As to those documents that might well be tainted by misconduct, I think any executive privilege interest would be quite weak.
Professor Turley, you would agree with that, would you not?
I'm not too sure, in terms of where it's on the spectrum, in terms of the executive privilege interests raised by this, there's no question that when this body is investigating crimes, for example, the assertion of privilege is at its weakest. But just as the
And
other
let me
witness-
interrupt you also.
Yeah.
If we're using our oversight power to investigate crime, that is within our legislative prerogative, is it not?
It is, but just
We
as
don't
the
have
other-
to limit ourselves to an impeachment inquiry in order to ferret out criminal misconduct.
Well, you don't
executive
have to, but the problem you're going to have in this, and a prior witness noted that the finding of no criminal conduct worked against the White House. This is where it works against the committee. The record as it stands
Well, we know
now-
that was unsupported, though. We know that assertion by Attorney General Barr was unsupported by the Mueller report. Wouldn't you agree with that, Professor Rosenweig?
Well, yes, Congressman. I joined a letter signed by, I think it's almost 1,000 former prosecutors now, suggesting that in our professional judgment, the Attorney General's determination was not supported by the evidence.
And with that, Mr. Chairman, I'll yield back.
Thank the gentleman from Ohio, Mr. Shabbat.
Thank you, Mr. Chairman. This is the Judiciary Committee, a committee that was once chaired by Daniel Webster, and we should be using our time in important, productive ways. We could be working, for example, on improving control at our borders, and it's a real problem. Some had tried to say, oh, this is just a made-up issue, a made-up crisis. More and more they're coming around and realizing that it's not at all a made-up crisis. At the very least, we ought to be able, in a bipartisan manner, to do something about the very flawed asylum system right now that we have. We have people coming up principally from Honduras and Guatemala and El Salvador, some on caravans. They're coming to our borders. They're told by the drug cartels who they've paid thousands of dollars to the magic words to say that they fear if they're sent back, and so they don't get sent back. They come into the country. They're given a court date. They're put on a bus. They disappear somewhere in the continental United States into communities from members on this committee and all over the place. Almost never come back for their court date and essentially just disappear into the population. It's not good for the country. The American taxpayers are paying for this. And this committee ought to be working on that. We have jurisdiction over that. We could be working on the record number of opioid deaths in this country. 70,000 over the last year alone. When Ronald Reagan was president, he and the First Lady started their Just Say No campaign to try to do something about it because we had 10,000 deaths due to overdoses, 10,000. Now it's 70,000, 7 times what it was. And in Congress's defense, we've done some things. We passed CARA a few Congresses back, and we passed the Support Act in the last Congress, and that does make progress. But there's so many other things we could be doing. We have jurisdiction, oversight over the DEA, the Drug Enforcement Administration, and this committee over the FBI, law enforcement. Yet we're having hearings on this. We could be talking about reforming our prison system. Now, yes, we did do some second chance legislation. That's a good first step, and we did it in a bipartisan manner, which we ought to do a lot more in this committee than we do. But these folks that are behind bars right now are going to be out someday, most of them. And if they have a skill, if we can actually do something with them so they have a skill, there's much less chance when they get out that they're going to be breaking into your house or hijacking your car or selling drugs to your kids. We ought to be working on that in this committee, but we're not. We're doing this. Anti-Semitism is a growing problem. We've talked about it, but we've got literally members of our own institution who can't get out of their own way. They've demonstrated their own anti-Semitism. So what do? We pass this legislation that says all hate is wrong, you know, but we didn't focus on what the real problem was because it was too embarrassing. We've got over a $20 trillion debt hanging over our heads. Now, we're not the Budget Committee, but we do have jurisdiction over constitutional amendments. I was for 6 years the chairman of the Constitution Subcommittee in Judiciary, and my ranking member for those 6 years was none other than the current chairman of this committee, Mr. Nadler, and we worked together on some issues, and we need to balance that budget. $20 trillion. It's like every American pays a mortgage on a second home, and yet they're getting nothing out of that home. That's what the lack of a balanced budget amendment does. We've introduced it again. We've got 36 Republican co-sponsors, 0 Democrat co-sponsors. We could be doing a lot more in these and many other issues, but Democrats are focused on something that's essentially already been dealt with in the Mueller report that found that this president had not colluded with the Russians, and Attorney General Barr indicated no obstruction, but our Democratic colleagues just can't leave it alone. So today we're wasting this committee's valuable time on executive privilege and blah, blah, blah. Professor Turley, let me ask you this. You had an article in The Hill recently, and in that article you said the Democrats wanted to manufacture a conflict, and they have succeeded in doing so. What did you mean by that?
Well, that was a column on the contempt action against Attorney General Bill Barr. And for full disclosure, I testified at his Senate confirmation. I've known him for years. I believe that the contempt action of this committee was unfounded, but I also believe that if it goes to a federal court, this is another area where I think that this committee could lose. The issue of Rule 6E was addressed during the confirmation hearing when senators asked me, why won't he commit to releasing the full and unredacted report? And I said, because that would be a crime. You're asking him to commit to an act to secure confirmation that would violate the federal law. If he had said that, despite our friendship, I would have opposed his confirmation because that would be unethical. So there's no question that he cannot release that Rule 6E information. I was counsel in the Rocky Flats case. That's the largest Rule 6E case I know of. We spent years trying to get that special counsel report released. So I'm not a fan of Rule 6E, but we lost. And if you take a look at the McKeever case, which was just handed down by the D.C. Circuit, you are heading into a world of hurt if you go to the D.C. Circuit and argue that you could order Barr, or that Barr could unilaterally release Rule 6E information. They just adopted a narrow view of Rule 6E. And by the way, their view, and I agree with the dissent in that case, raises serious questions about how they're interpreting Haldeman versus Sirica. So you could open up that fight if you bring that case back to the D.C. Circuit. I'd encourage you not to, because I happen to like Haldeman versus Sirica. But right now, the D.C. Circuit is not a hospitable place. They have adopted the narrower approach of a couple of circuits, like the Eighth Circuit, in interpreting those exceptions under Rule 6E.
Thank you. My time's expired, Mr. Chairman.
The gentleman from Florida, Mr. Deutsch.
Thank you, Mr. Chairman. Mr. Chairman, on April 18th, an hour before releasing the Mueller report, the Attorney General held an unusual, misleading press conference to spin Mueller's findings in the president's favor, and he said, and I quote, "The White House provided unfettered access to campaign and White House documents, directing senior aides to testify freely and asserting no privilege claims. And at the same time, the president took no act that in fact deprived the special counsel of the documents and witnesses necessary to complete his investigation. Accordingly, no material has been redacted based on executive privilege." Professor Shaw, the president had multiple opportunities to assert executive privilege over materials collected during the investigation, but he did not. Is that correct?
That's correct.
And the Attorney General sought to make a point, he sought to point out the decision to waive privilege, to make it appear that the president was being fully transparent with the American people. Is that correct?
I think that's a fair characterization of the press conference, yes.
And the Attorney General said nothing in the Mueller report was redacted for executive privilege.
That's correct.
Professor Kinkoff, in the course of the investigation, what third parties would have access to information and documents collected?
I'm sorry, could you?
During the course of the investigation, which third parties would have access to the information and documents collected? Like investigators, for example, or private attorneys or staffers, would they have access?
Would they have access to the special counsels?
To the information collected during the investigation?
No. I mean, the internal staff would.
Right.
Yes, yes.
Exactly. Are those individuals the sort of close advisors to the president that executive privilege is meant to protect?
No.
Right. So given that the White House made no executive privilege claims at all during the special counsel's investigation, including witness testimony, or over the publication of the report itself, should that information still be considered privileged?
Certainly not presidential communications privilege.
Right. So to be clear, the president waived, Professor Shaw, I'll come back to you, the president waived executive privilege over these materials when he gave them to third parties and allowed them to be published publicly, correct?
Congressman, the counter-argument that I would offer is just that because these were all executive branch officials to whom these documents were shared without any interposition of an objection on the basis of executive privilege, that does not necessarily mean the president wouldn't later assert executive privilege as to another branch.
When the document was released, the Attorney General went out of his way to talk about transparency in the process and made no mention of executive privilege.
I agree that
Right.
that seems misleading in retrospect.
In fact, it seems to me that the D.C. Circuit decided this exact issue when it held that the White House, quote, waives its claims of privilege in regard to specific documents that it voluntarily reveals to third parties outside the White House. That's the Espy case. So the Attorney General has also claimed that he is prohibited by law from disclosing the report's underlying evidence, including investigative files. Mr. Rosenweig, based on your experience, is the Department of Justice prohibited from giving Congress law enforcement files?
It's not prohibited by law except to the limited extent of matters that are actually occurring before the grand jury, which is actually a very narrow case. My own experience...
What was your own experience?
Well, my own experience 20 years ago was an investigation conducted by former Chairman John Dingell into a specific case in which the department turned over essentially the entire investigative file, save for the grand jury materials, and I personally sat for several hours of depositions on the matter.
Right. And in fact, Professor Shaw and Professor Kinkoff, in your time serving as attorneys in the executive branch, is it standard practice to refuse to disclose law enforcement information to Congress? Is that standard practice?
Yes.
Professor Shaw, standard practice to refuse to disclose law enforcement information to Congress as a whole.
In a blanket way, I would say no. I think as to specific materials, it is sometimes occurs.
I would agree with that. In a blanket way, no, but
Thank you, Professor
as to
Kinkoff.
specific investigations
Thanks.
that are ongoing.
So there is not a basis to withhold this information across the board. It's just not, that's just not the case. But the Attorney General and the President are still claiming a blanket privilege over all of the Mueller report and all of the underlying material that's been shared by the special counsel, shared with investigators on his team, shared with fact witnesses, former White House employees, shared with private attorneys, shared, in fact, with the ranking member of this committee. So additionally, I reviewed the White House counsel Cipollone's letter from last night. It leaves me with the same impression that the Assistant Attorney General did in his letter last week. The blanket protective privilege claim wasn't grounded in the law. It was payback because the White House and DOJ didn't want to comply with the subpoena, didn't want to negotiate compliance, and didn't want the Attorney General to be held in contempt for refusing to comply. It's important to note what's going on here, Mr. Chairman. The Attorney General came out in front of the American people and claimed transparency that the President didn't hold any documents back. He didn't assert a privilege. The President waived it. He said he didn't need it. The Attorney General boasted about it, and then he tried to claw it all back, not because the law says he can't, but in retaliation against this committee because we demanded compliance with our subpoena and move forward with contempt. It's too late for a privilege claim now. The President's decision to use it as a cover-up has thrown this system of checks and balances out the window. Yes, the president has a limited qualified privilege to enable him to do his job. It is not a blanket cloak of secrecy to cover up his own wrongdoing, to make it impossible for Congress to protect the Americans' health care, ensure we aren't committing human rights abuses at our border, protect our national security from vulnerabilities when security clearances are inappropriately given to family members. There is no cover-up privilege in our law. Mr. Chairman, the Constitution, law, and precedent say that Congress has a right to this information. We will go to court if we have to get it. The president cannot prevent Congress from investigating obstruction of justice by obstructing this Congress, and I yield back the balance of my time.
Yielding back, the gentleman from Texas, Mr. Gohmert.
Thank you, and I appreciate my 6.5 minutes time I'll have. First of all, I know it's difficult these days because schools teach to the federally mandated tests, so they don't include civics. But anyway, and I know surveys have shown that more college students and recent college graduates can identify the three stooges more so than they can identify the three branches of government. But let me help in that regard. When the President of the United States tells the Attorney General that he is going to waive executive privilege with regard to things that he has used his White House counsel for and met with him and shared things with, that does not waive the executive privilege outside the executive branch. Because, see, we're a legislative branch, one of those three, and so the executive privilege can be contained within the executive branch without waiving it to another branch. So I know it's an acute difference, but it is worth noting, especially if you're going to go before a court that does know the difference between the three branches. And by the way, just for what it's worth, we've had a couple of weeks of hearings on what was called the Equality Act. We're supposed to, the majority is going to pass that out apparently this week. First bill in 25 years where you cannot have a religious freedom defense. So if you, for example, advise a synagogue, you may want to tell them that if they refuse to hire a biological woman who says she's a man and wants to be their rabbi, they're looking at a lawsuit and they cannot claim religious freedom in doing so. There's a lot of changes coming if that bill becomes law, so just a heads up on that. Now, we're living in a time right now that history is going to document. I don't know how much more this little experiment in self-government is going to go, but history will document what is now coming out. You had a former member of the Trump campaign who was lured overseas to meet with an FBI or DOD, apparently gets money from different sources, person who invited him. He's set up to meet another foreign official who tells him the Russians have Hillary Clinton's emails, and so that when he shares that with another setup, then that is used to go get a FISA warrant to spy on a campaign. We are in a historic area, and what we're seeing in this committee as, and I know this was with regard to a different thing, but Professor Turley's world, flailing. This committee is flailing after the gates opened and the evidence has started coming out. Now, I have seen the chairman react when he feels like things are going unfairly and he forgets some of the rules and misapplies some of the rules. And I get the impression if this chairman had been set up the way the Trump administration and the Trump campaign were, by an intel community abuse, a FISA court abuse, a DOJ FBI abuse, then I have a feeling that this chairman would be reacting far more in the flailing area than the Trump administration has been acting. They have been done terribly wrong, and I am hopeful we'll get to the bottom of this, because if we don't, then this will continue. We should have gotten the clue when the FISA court order, the application, the affidavit were released through WikiLeaks, letting us know they're using applications with no regard for the Fourth Amendment, no particularity as to what's to be searched or the things to be provided. They just wanted all the information Verizon had on everybody. And the judge said, oh, okay, and he signs off. Here, you can get everything they've got. That should have been the clue. We've got to start having hearings on the FISA courts. And I would love to get this same group back and have a good discussion on the abuses of the FISA court. I'm about to come to the conclusion we may need to just get rid of them altogether. They have become so abusive, and the fact that no FISA court has reacted violently to having a fraud committed on the court raises the issue of perhaps if we had a FISA judge or more who were part of this scam to take down a duly elected president. So this is a very important time. Everybody's questions will be part of the record, and you need to know that someday, after all of this has continued to come out and we get all of the truth, what side of history you want? Were you continuing to flail at a candidate you didn't want elected, or are you going to help restore a Department of Justice and a court system that used to be the envy of the world? Because we're sure not right now. I yield back.
I thank the gentleman for yielding. I would observe that this chairman could not be so set up because this chairman never ran a political campaign that had 180 contacts with a foreign power. The gentlelady from Texas is recognized.
Mr. Chairman, thank you so very much. And as a member of the Homeland Security Committee since the heinous act of 9/11, I can assure you that the FISA court, although there needs to be firewalls, have over the years protected this nation from heinous and horrific terrorist acts. It is a fixture that is important, and it has done work that is valuable to saving lives in this country. Let me, Professor Kinkoff, and let me also say to each and every one of you, thank you so very much. As a member of this committee, hearing your constitutional perspectives is much appreciated. Let me indicate that recognizing the executive privilege as a fixture now in the law, not a constitutional, it's not so stated in Article 2, but would you say, Mr. Kinkoff, that the recognizing executive privilege, it cannot be used, however, to interfere with the constitutional prerogatives of the United States Congress?
I think that's right. It has to be balanced with Congress's authority.
Thank you. Professor Turley, yes or no?
I'm afraid it can, because the point of privilege is that it will sometimes trump committee requests, and so courts do balance, but at times that balance favors the White House.
But it is not an absolute bar.
Oh, absolutely. Yeah, that's true. Yeah.
And there are potentials where it does not act in place. There are potentials. Yes.
Yes, and in fact, this committee and the Congress overall prevails in many of these fights.
I thank you. I need to proceed with my questions. Thank you so very much. Let me read this, please. The final area of conflict concerns whether certain key witnesses can be prevented from appearing before Congress. The President has stated publicly that he opposes the appearance of witnesses like Robert Mueller and Don McGahn. For his part, Attorney General Barr has stated that he believes that Mueller should testify, but regardless of the position taken on these witnesses, Congress is again in a strong position to demand their appearance. It would prevail ultimately in any litigation, and this is a fight that would be excellent ground for litigation on the part of the legislative branch. Based on these words, Professor Kitkoff, do you agree that nothing should prevent Mr. McGahn from appearing before this committee, or that the President should not be able to prevent that?
Yes, I agree.
As you well know, Professor Turley, these are your words in your testimony. Do you agree that nothing should prevent Mr. McGahn from appearing before this committee?
I'd have to agree with that excellent testimony that you read from, yes.
It is good to have scholars in the House. Let me also share with you words that were said in July 16, 2014, and I will ask each of you yes or no. This is testimony given, and Professor Turley and I would consider each other at least Judiciary Committee friends. We've seen each other in this room for a very long time. The fact that a majority in Congress, testimony before the Rules Committee, can remain silent or acquiesce to unconstitutional actions is regrettably nothing new to our country. However, such failure of principle does not change the character of an unconstitutional act. Professor Shaw?
I would agree with that statement, yes.
Professor, forgive me.
It's okay. Rosenzweig.
I'll get it, Rosenzweig. The glasses are not strong enough.
I agree with that testimony.
Professor Turley?
Yes, I think that's true.
Professor Kitkoff?
Yes.
There has been no legislation that has dealt with the executive privilege. We have taken it in a sacred manner that it works collegiately with Article 1 and Article 2. In light of our present atmosphere, not that we should be raging against this document, but Professor Shaw, what legitimate interest does the President have in protecting the confidentiality of White House communications or documents that may contain evidence of misconduct? Now, this is being used. Would you answer both that and the idea of some sort of congressional framework given to this use, seemingly unfettered power of executive privilege?
Well, so the general underlying sort of theory is that the president has a need for and entitlement to unvarnished advice from advisors, and that it would chill the sort of free flow of that advice to too lightly tread into sort of those confidential communications. But as I said, when there's some threshold showing that the materials sought might reveal misconduct, any legitimate claim to secrecy, I think, is quite eroded, if not, vitiated. In terms of the framework, I think it's a difficult framework to encapsulate in a couple of sentences. I think there are very strong, legitimate, constitutionally grounded interests on both sides of the balance, and so it's a really fact-specific kind of an inquiry and a balance, which is, I think, what is so problematic about the kind of blanket assertion that we see here. It's impossible to evaluate the strength of the White House's legitimate need and balance it against the strength of Congress's legitimate need in the abstract. It needs to be sort of a document by document and event by event sort of analysis. But at the end of the day, I don't think a blanket assertion of the sort we have seen here can possibly withstand scrutiny.
Which is what is acting and going on at this point. Quickly, Professor Kitkoff, could you just comment on that?
Sure. I completely agree with Professor Shaw. And so normally what would happen is the executive branch would produce a privilege log that lists the documents being withheld and lists specifically as to each document the rationale for its withholding. That allows then the process of negotiation and accommodation. It allows a court to assess if there's an impasse in that negotiation process. And the blanket assertions of privilege that we've seen from the Trump administration just do not facilitate that process.
I thank you very much. I think that has been enlightening for all of us, and I may be judicious in looking at legislation dealing with this question. Thank you. Thank you very much.
I think all members of the Judiciary Committee should be judicious. Thank you. Now recognize the gentleman from Colorado, Mr. Buck.
Thank you, Mr. Chairman. We are here today because my colleagues on the other side of the aisle are throwing a tantrum over information they want, but no, they cannot have. Not because Donald Trump says so, not because Attorney General William Barr says so, but because the law says so. It's important to understand that there is no constitutional crisis, as the chairman asserted last week. My friends on the other side of the dais can only blame themselves for the current stalemate with the administration, the unreasonable demands, lack of accommodation, and bad faith subpoenas. I want to highlight 3 reasons we are faced with the current impasse. First, the majority rejected an effort to work with Republicans to tailor a subpoena most likely to lead to the production of documents that Democrats say they want. On April 18th, the chairman issued a subpoena for the full, unredacted Mueller report. This subpoena presented the Attorney General with 2 terrible and unfair choices: violate federal law and disclose grand jury information to comply with the subpoena, or uphold the law and only partially comply with the subpoena. At the subpoena markup, I offered an amendment to carve out grand jury materials from the chairman's subpoena. This would give the Attorney General a subpoena he could legally comply with and would have resulted in the production of documents. So how did Democrats respond to that common sense approach? The chairman spoke against my amendment. Democrats voted in lockstep with their chairman, and my amendment was defeated on a party line vote. What's ironic here is the Democrats' remarkable flip-flop on this issue. They voted to protect grand jury materials on March 14th when they voted for the chairman's resolution on the floor, but then voted against the same protection in committee. Attorney General Barr predictably could not comply with the issued subpoena. That was not his choice, it's the law. The blame for this lies with the majority. The second reason we have an impasse is because of the chairman's unreasonable demands in terms of timing. It took Special Counsel Mueller and his team 22 months to conduct their investigation. That's 675 days. He had the assistance of 19 prosecutors and 40 FBI agents. His team issued 2,800 subpoenas. They executed 500 search warrants. They conducted 500 witness interviews. They received court orders for 50 pen registers, had contact with 13 foreign governments, conducted 2 pre-dawn SWAT raids, spent $35 million, and reportedly produced over 1.4 million pages of documents. How much time did the chairman give the Attorney General to comply with the subpoena to review over 1.4 million pages of documents? 13 days. 13 days, that's it. If Democrats were acting in good faith, you would have asked only for what you knew the Attorney General could legally provide, and you would have given the Attorney General sufficient time to process the request. Before the Oversight Council noticed a markup to hold Eric Holder in contempt of Congress, Mr. Holder was given 174 business days to comply with the subpoena. Congress even gave him a second chance by issuing another subpoena. How many business days did Chairman Nadler wait before noticing a markup to hold Attorney General Barr in contempt? 3 business days. When the majority uses unreasonable timeframes in a subpoena and then moves so quickly towards contempt, it shows the motive. It's not to obtain information, but rather to pick a fight. Finally, my friends are to blame for the current impasse because the chairman and the majority are playing fast and loose with the facts and misrepresenting precedent. Professor Turley, the Judiciary Committee issued a subpoena to Attorney General Barr, is that correct?
Yes.
And when considering the subpoena, does the Attorney General have to comply with the Federal Rules of Criminal Procedure 6E and how to handle grand jury material?
Yes.
If the Attorney General released grand jury material to this committee without a court order allowing him to do so, who would be liable for that action?
Well, he would be in violation of federal law. Also, some of this material beyond Rule 6E, dealing with ongoing cases, may involve prosecutions like that of Roger Stone. Some of that material may be under court order not to be released because they're ongoing prosecutions. So once again, to release that information, he has to go to a different judge to ask if the information can be released. Now, all of that states the obvious, and that is he's between the horns of a dilemma here if the choice is to comply with Congress and violate standing court orders or Rule 6E. And I think that's what caused this obvious conflict between the 2 branches.
And I heard earlier one of my colleagues on the other side of the aisle mention the president waiving executive privilege by saying that he wants to be transparent. Is that a waiver of executive privilege?
No, the public Mueller report itself is a giant waiver.
No, I'm just saying, if he holds a press conference and says, I want to be transparent, has he waived executive privilege?
No, it's not. But I also don't believe that the administration is claiming that the public report itself is subject to executive privilege. What they're claiming is that the subpoenaed material, the stuff that was not published or released, is subject to this preventative executive privilege assertion.
Have you ever reviewed 1.4 million documents?
Well, my tenure piece was pretty long, but not quite that long.
Okay.
Yeah.
All right. Thank you. I yield back.
Thank you, gentlemen, for yielding. I now recognize the gentlelady from California, Ms. Bass.
Thank you, Mr. Chair. This is a question to the entire panel. The President recently declared that he is fighting all subpoenas issued by Congress. And I wanted to know, in all of your different government experiences, have you ever heard a president say or do something like that?
If I should start, Congresswoman. No, I have not. I will say that I do think that background fact is relevant to this committee's task, but equally relevant, if not more relevant, I think, is the conduct of the executive branch vis-a-vis this committee's requests, and that conduct does seem to have been quite consistent with that sort of baseline decision to essentially resist completely cooperation with this committee's oversight undertakings.
Thank you.
I would agree. It is a unique circumstance. Kerry Kersher, who was the general counsel of the House under Speaker Boehner and Speaker Ryan, and before that deputy general counsel in both Republican and Democratic administrations, said nobody in the executive branch likes congressional oversight, but heretofore everybody recognized it had its place. You mostly argued about degrees. Now we're not arguing about degrees anymore. We're arguing all or nothing, and that's a significant escalation. This is a unique circumstance.
Thank you.
I would have to offer a more nuanced view on this because this is not the first time a White House has defied Congress. During the Obama administration, during the Clinton administration, there was defiance of this body. In my view, they were wrong.
Well, the question is all subpoenas.
No, I've already been critical that I think that the assertion is wrongheaded. It cannot be sustained in its current force. What they're relying on is an opinion by Janet Reno that made a similar type of preventative type of assertion. That's never been tested in court.
Thank you.
That preventive assertion was with respect to a specific subpoena. Never before has there been a blanket assertion that an administration will stonewall all subpoenas and all requests for documents. And when I think of a word to describe that, the only one that comes to my mind is contemptuous.
Can executive privilege be invoked because the president believes Congress has a political agenda? So have you ever seen executive privilege invoked because of that opinion?
For me?
Yes.
So, no. If Congress's only motive is a political motive, that's not a legitimate legislative interest. But the fact that Congress might have political motives in addition to legislative motives is not only doesn't vitiate, it's not surprising. It is the premise of the Constitution that both Congress and the President will have political motives when they act. So that motive alone doesn't tell us anything. The only question is, do you have a legitimate interest as well? And in this instance, you do.
And Mr. Rosenwick, I would ask you the same question as well. Can executive privilege, and have you seen it in your experience, be invoked because of a president believing that Congress has a political agenda?
No, that would be most unusual. As Mr. Kincock said, Congress always has some political motive. That, after all, is what you're here for. But here, the committee clearly has legitimate interests, both in, as the chairman said, in examination of Russia's role in the 2016 election, what to do about it in the future, the president's interactions with the Department of Justice. All of those are perfectly legitimate legislative matters. The fact that they, in addition, this occurs in a political environment is simply the necessary consequence of the fact that government is run by politicians.
So as we said, ordinarily Congress tries to avoid resorting to subpoenas in the first place, but we have seen a troubling pattern with this administration where our requests for information are just ignored altogether. For example, the administration has repeatedly refused to respond to our document requests on topics like its refusal to defend the Affordable Care Act in court, its failure to enforce the Voting Rights Act, or its cruel policy of separating children from their parents at the border. Professor Shaw, would that have been normal behavior in the White House counsel's office? And can you recall any other examples similar to that?
I would say absolutely not. I think it is certainly customary for White Houses to attempt to narrow requests, so to sometimes find themselves unhappy with requests, but to just ignore repeated requests from congressional committees is something that I don't believe there's any precedent for, no.
Well, I think my colleagues on the other side of the aisle suggested that maybe the administration didn't have enough time to respond, that there were a lot of documents. And so how long generally would be reasonable to respond?
So I agree that this committee has moved quickly beyond the initial sort of request stage to subpoena to then the contempt vote. But I think that was and is to a degree justified by the total lack of response from the administration. So I think that some fairly dramatic step on the part of the committee was appropriate to counter what I view as a very dramatic step of complete noncompliance. Responding to try to narrow requests is absolutely customary, but a failure totally to respond and to produce any sorts of documents, that I think is a quite extraordinary step, and I think largely does justify an escalation on the part of the committee.
Mr. Rosenberg? Oh, is my time up? Go ahead, could you?
The lady's time has expired. The witness may answer the question.
I would agree with the professor, and I would also add that, of course, in cases of large volume, this committee and criminal investigations as well often receive documents on a rolling basis, in which you begin your production and you explain that there are a lot. It'll take us a few weeks to do it, or a few months, and that sort of accommodation would also be very reasonable. My understanding, it too has not been put on the table by the department.
Gentlelady's time has expired. The gentleman from Arizona, Mr. Biggs.
Thank you, Mr. Chairman. Thank you to all the witnesses for being here today. Executive privilege is a critical protection for the executive branch in our separation of powers scheme. And if presidential advisors know that their candidate advice is subject to subpoena by political opponents, the effect will be that advisors are less willing to give candidate advice, as Professor Shah has previously testified today. However, invoking privilege preventing access to documents should be done sparingly and err on the side of transparency. But nonetheless, congressional overreach in the form of abusing the oversight process and using the legal process for political purposes is also a genuine and legitimate concern, and that's exactly what this chairman has been doing. I'm concerned with the effect of the chairman's actions on this institution. As I iterated last week, there are so many other things that could have been brought before this committee rather than a contempt hearing and citation. Open hearings with Mr. Barr, who was willing to come and testify, who testified in the Senate, Mr. Rosenstein or Mr. Mueller, a closed hearing with Barr, Rosenstein or Mueller, etc. Well, by submitting a sloppy subpoena, a subpoena that was overly broad, unenforceable demands, the chairman has risked doing lasting and real damage to the Judiciary Committee in the House of Representatives because bad facts make bad law. So I also want to comment on something that Ms. Shah just testified to, and she was kind of ameliorating something that she said in her written statement. She said, one of the categories of information, this is from page 10 of her statement, presently sought by the committee appears so broad as to put the executive branch officials to a nearly impossible task. The third item on the committee's subpoena consists of all documents obtained and investigative materials created by the special counsel's office. And we know that the investigation involved more than 2,800 subpoenas, 500 warrants, 250 communication records orders, and over 500 witnesses. What she doesn't mention is that it also produced 1.4 million documents. In light of this volume, the committee cannot, in good faith, expect compliance. Accordingly, the burden is on the committee to substantially narrow this aspect of its request. Contrary to what Mr. Rosenzweig just testified to, Ms. Shah has written that the burden is on the committee to substantially narrow this aspect of its request. If this committee were willing to accept rolling submission of documents, why did it not so state, and why did it pull the plug on accommodation negotiations with Mr. Barr and his office? This committee, Ms. Shah continues, the committee appears to believe that the executive branch is essentially withdrawn from the process of negotiation, providing affirmative authorization for Congress to do the same by moving quickly to a subpoena and then contempt vote. These developments do not, however, relieve the committee of its obligation to continue to negotiate, to frame requests with specificity and care, and where possible narrowly, both to potentially achieve some sort of resolution outside the courts and to allow the courts to adjudicate a narrow dispute if and when one party invokes their jurisdiction. We have rushed instead in this body, as my colleague from Colorado, Mr. Buck, so eloquently stated, we've rushed to invoke the court's jurisdiction by hurriedly issuing a poorly drafted and overbroad subpoena, which, by the way, this committee in its hearing last week attempted to narrow the scope of the subpoena by amending the motion to hold in contempt. Think about that. You've given Mr. Barr a subpoena. You've demanded all documents. And then when it comes time to hold them in contempt, you say, well, we didn't mean this type of information. Well, then how in the world do you think he could be held in contempt? Using the committee's oversight authority and subpoena authority for partisan political reasons, refusing to work with DOJ to narrow the request to information that is legitimately within our jurisdiction, and putting on show hearings demanding that the AG submit to staff questions and then later holding him in contempt damages the credibility of this committee. Issuing a subpoena that is overly broad and attempting to narrow it when you're holding the person in contempt not only is sloppy, but it shows that this is being done for a partisan purpose to undermine, to pick a fight, and not to get the documents, not to get at the truth, especially when this chairman refuses to go down and look at the documents that have been provided to him, with only 2% of the documents even being redacted. With that, my time has expired.
Time of the gentleman has expired. The gentleman from New York, Mr. Jeffries.
Thank you, Mr. Chair. Mr. Rosenzweig, in your opinion, does the House Judiciary Committee have a legal basis for seeking disclosure on a confidential basis of the grand jury materials that are subject to Rule 6E?
I believe it does. I believe that would be strengthened if impeachment proceedings were to begin, but I believe that the McGeever case is distinguishable on the grounds of this committee's superior legislative interests.
Now, separate and apart from the question of impeachment proceedings, the chairman has previously announced that this committee will pursue an inquiry on 3 different subjects. 1, obstruction of justice. 2, abuse of power from the administration. 3, the culture of corruption that could possibly exist at 1600 Pennsylvania Avenue. Do those 3 independent subjects provide a basis for which we should have a firm foundation to seek this grand jury material?
In my judgment, yes. I would say that all of those are suitable and cautious preliminary steps in anticipation of the possibility of considering impeachment, and therefore this committee has not only a legitimate oversight interest, but one of the highest constitutional moment.
Thank you. Professor Shaw, does executive privilege cover communications the president has with private citizens who do not work at the White House?
I don't believe so, no, Congressman.
Does anyone on the panel disagree with that position?
Well, I'm not too sure how I'd answer that. In my testimony, I get into the question of attorneys, private attorneys, and that's a difficult issue that I discuss in the testimony. A court could very well create new law that this committee would not welcome if you push that issue.
Okay, Professor Turley, would the assertion of executive privilege cover communications between the president and Corey Lewandowski, who is not an attorney?
No, I think that would be a disclosure to a third party. Although, as I mentioned in my testimony, when it comes to waivers to third parties, the courts have been somewhat restricted in how far they'll allow that waiver to go. The SB case that was referred recently, the court said quite clearly they will not, quote, lightly infer a waiver when it comes to executive privilege.
Right. Roger Stone is not an attorney, correct?
I have no idea, fortunately.
Okay, we can stipulate that he's not. So I would assume that executive privilege does not blanketly cover communications with Roger Stone. Is Donald Trump Jr. an attorney?
Once again, I have no knowledge of their backgrounds.
We can stipulate that he's not. I would assume that a blanket assertion of executive privilege does not apply with any degree of reasonable force to Donald Trump Jr. Is Paul Manafort an attorney?
Once again, I don't know.
Okay, let's stipulate that he's not. I would assume that the assertion of executive privilege does not, in a blanket fashion, cover communications with Paul Manafort. Chris Christie is no longer a practicing attorney, is that correct?
Once again, I have no idea what his practice is.
Okay, yeah, I would assume that the assertion of executive privilege does not apply in a blanket fashion to him either. Now, Professor Shaw, in the context of this question of waiver, it does appear that several White House employees talked to Bob Mueller and his investigators in the context of the preparation of the Mueller report without the administration asserting executive privilege. Is that right?
I believe that's right, yes.
And so Hope Hicks talked to the Mueller investigators without the assertion of executive privilege, correct?
That's correct.
And Sarah Sanders talked to the Mueller investigators without the assertion of executive privilege. Is that correct?
That's correct.
And I even think that Don McGahn, the White House counsel, talked to the Mueller investigators without the assertion of executive privilege. Is that correct?
Yes, also correct.
And so what impact, if any, does the fact that the administration did not see fit to assert executive privilege in the context of an incredibly public investigation that the president tweets about every other day, but failed to assert executive privilege, and now, after the fact, want to put forth this blanket assertion?
You know, again, I think it's a difficult question. I think the argument would be that to choose not to assert executive privilege in the context of an investigator inside the executive branch, which of course Special Counsel Mueller was inside the Department of Justice, is different and doesn't necessarily waive the opportunity to, at a later date, assert the executive privilege as against, say, Congress. As I said, I am not predicting that the White House would absolutely prevail in that argument, but I do think that it's a close legal question and that it is not at least evident that by failing to object at this earlier juncture that the White House has for all time necessarily waived privilege as to all the contents of those communications when a body like this committee is seeking them.
Okay, 17 different intelligence agencies concluded that Russia attacked our democracy as part of an effort to try and artificially place someone at 1600 Pennsylvania Avenue. Does Congress have a strong public interest in getting a full understanding of what happened, how it happened, and how we can figure out how to prevent that from happening again?
I would say absolutely, an incredibly strong interest, yes.
Thank you. I yield back.
Thank the gentleman for yielding. The gentleman from Virginia.
Thank you, Mr. Chairman. Well, here we are again at the latest installment of the dramatic mini-series, the impeachment by any other name but impeachment. Masking as oversight, this committee has continued to drag on with questions about the Mueller report, what is behind the redactions, and the lack of attention to the actual issues that the American people are concerned about, securing our borders and addressing the immigration crisis, the opioid epidemic, as was addressed earlier. And as my colleague just mentioned, Volume 1 of the Mueller report spells out in detail just how Russia tried to influence our elections. The previous administration didn't do anything to address it. The current administration and this Congress need to work together to address it. But what we have instead is this committee driven by animosity for the president, pushing to see what's behind the redactions, and yes, I'd love to see what's behind the redactions in compliance with the law, but that's not what the subpoena said. The subpoena said the entire Mueller report must be made available in violation of federal law. So we're waiting to see how that works itself through the courts, and as was testified to by Mr. Turley, we have played our weakest hand. So what's happening now? Well, now we're starting to hear that the Attorney General, wisely, has started to ask if we got it so wrong on the collusion question, then what actually did happen with the FISA court? What actually did happen with the investigation? And he has appointed U.S. Attorney Durham to investigate what exactly happened through that process. It's very appropriate that he's done that. But instead of supporting a U.S. attorney who has done work in previous administrations on both sides of the aisle, what we see is this committee trying to take the reputation of a good man, this Attorney General, and drag it through the Washington mud, claiming that by not releasing grand jury testimony, he is somehow in contempt of Congress. Well, he's actually complying with the law, not trying to thwart the enforcement of it, and this committee should be appreciating rather than trying to muddy up the reputation of the Attorney General. So I want to focus on an example of just how ridiculous this whole process has become. Mr. Chairman, you laid out in the case for contempt, you raised 3 complaints against Barr, and these were outlined, Mr. Turley, in your article in The Hill, and I would ask you to elaborate on them. The complaints are a failure to release an unredacted report, which you've addressed, and which is in the contempt citation, even though he's prohibited by law from doing so, making false statements, and his refusal to follow a subpoena. Can you expand on why those 2 were left out of the contempt citation?
No, I don't know why the committee left out the common allegation that General Barr lied repeatedly to the committee. I disagree with those allegations. I don't see where perjury occurred. In terms of his record, I believe that he fulfilled his commitment to the Senate Judiciary. He said he would release as much as possible, as fast as possible. In his testimony to the Senate, he said that he asked Mueller to identify grand jury materials so that they could rapidly release the report. I'm still quite surprised that that request made by both Mueller's superiors was effectively ignored. The report came without identification of grand jury material, and that slowed the process. But in the end, the public report was 92% unredacted. To be honest, I thought that was a remarkably high percentage, given the nature of this material. The report given to select members was 98% unredacted. My assumption then is that the grand jury material represents about 2% of the redactions. On that material, I can't imagine a court agreeing with some of the statements made here about his ability to release it. I tell my students all the time that only bad gamblers and bad lawyers focus on the prize and not the cards in their hand. This is not a good card to go to a court with.
Thank you, Mr. Chairman. I yield back.
Thank you, gentlemen. The gentleman from California, Mr. Liu.
Thank you, Mr. Chair. Let me just clarify that the Trump administration is not just denying requests from this committee, it's every single committee. So they're hiding information on every issue. Right now, we've got a committee trying to seek information on why the president and Bill Barr are suing to eliminate health care coverage for people with pre-existing conditions. We can't get that information. So let's just be clear of what's going on. Professor Turley, I have a question for you about the waiver of executive privilege. Attorney General Bill Barr gave some members of Congress, including the Republican ranking member of this committee, access to 98% of the report. I cannot see 98% of the report. Has the privilege been waived because Bill Barr clearly let members of Congress actually see a lot more of this report than I could? So would that have waived executive privilege?
You know, it's an excellent question. We haven't really seen a test on that because it's sort of a conditional waiver. It allows for some access. We see that in other cases involving classified evidence, for example. The question I would pose to the committee, the caution I would give them, is to not look at this through your eyes or the president's eyes, but look through it the eyes of a judge. When she sees this, how is she likely to draw this line? Judges are loath to create new law in this area. My guess is that the court will find that that is a conditional waiver for those members, that it's the lesser that is contained in the greater. But honestly, this has not been tested in court, so you can't say for certain how it would come out.
Thank you. And then, just want to make sure that, are you aware that we held Bill Barr in contempt, not because he didn't provide Rule 6E materials? You're aware of that, right? The contempt action excluded Rule 6E. We are very aware of how it works. The way, so I'm a former prosecutor, right? The way you do subpoenas is you have a broad subpoena, and then the opposing side said, okay, well, I can provide documents A, B, and C, but with respect to documents X, Y, and Z, here are the reasons we can't provide it, and then you go forward. So wouldn't a judge actually look at what we actually negotiated and try to ask for versus just what the actual subpoena says?
Again, that's a reasonable point to make. I must confess that if I were the judge, I would not be so inclined. What I would see is that in March of this year, this body did put forward a resolution that had two conditions. One, the first one was written nicely and said, you should release publicly the report as much as possible. The second condition said, we want the full report given to Congress with no distinction for Rule 6E. This committee has also repeatedly said it wants a full and unredacted report. On these questions are so close that you have to be careful in your language. I think the subpoena was a mistake the way it was drafted, honestly, because I think a court is going to look very closely at that and say, look, there's been this mantra that you want the full and unredacted report, and also the time you gave Barr, I have to tell you, I think judges are not going to like. They're going to see over 1 million pages of documents. They're going to see over a dozen cases ongoing that were involved. And I think that most of those judges would say, I would not give him that limited amount of time. And judges deal with these issues all the time. They produce indexes, they do reviews. I think the time you gave Barr will be viewed by federal judges as insufficient.
Thank you. And Mr. Rosenstory, I'd like to ask you some questions about obstruction of justice. You're a former federal prosecutor, correct?
Yes.
And you were the former Republican investigative counsel on the House Transportation Infrastructure Committee, correct?
Yes.
All right. And then you also signed on to a letter now with over 900 former prosecutors saying that if anybody else in America had been faced with this evidence on obstruction of justice, they would have faced multiple felony charges if they weren't Donald Trump.
I signed that letter, yes.
Okay. And that's because under the obstruction of justice statute, it's really quite broad, right? You don't actually have to complete an obstruction of justice act. You just have to endeavor to try obstruction of justice. Is that
That's
right?
exactly right. The statute says endeavor to obstruct, and typically such obstructions fail. Otherwise, we wouldn't. If they succeeded, we wouldn't know
So
about
it
them.
wouldn't really matter that Don McGahn said no. What mattered is if Donald Trump gave the order to obstruct justice.
That's exactly right, sir.
Right. Second, under the obstruction of justice statute, there is no requirement you have to commit a second underlying crime in order to be guilty of the crime of obstruction of justice. Isn't that right?
That's right. Many people would be very surprised to learn of that requirement since they languish in jail right now on that ground.
And in fact, lots of people get prosecuted for obstruction of justice because they want to protect a family member or a friend, or they're afraid of embarrassment from the investigations.
Or political reasons as well, yes.
Okay. So really, Bill Barr's theory that the president had to have actually committed criminal conspiracy with Russia is pretty cockamamie when it comes to obstruction of justice. You don't have to answer that. I want to ask you one more question on obstruction of justice.
I didn't want to characterize
Which is, the president would not have known if Michael Flynn, Paul Manafort, or others may have committed an underlying crime. So with respect to stopping investigation against them, that clearly would have been obstruction of justice, whether or not the president believed he himself had done anything wrong, isn't that right?
That's correct. You can obstruct justice by obstructing an investigation into a third party. It's not only limited to obstructing an investigation of your own conduct.
Thank you. I yield back.
Would the gentleman yield?
I'll yield to the chair.
Thank you. Just, Professor Rosenzweig, you were shaking your head vigorously a moment ago when Professor Turley was answering questions from the gentleman from California about how a judge would regard the contempt with reference to the fact that 6E was in the original, not the contempt citation, but in the original subpoena, but we wouldn't have asked for it because we made clear that we were just seeking his cooperation getting it. Could you comment on what you were shaking your head about?
Yes, I guess my thought is that I don't think that this committee's subpoena was poorly drafted or in any way unusual from the hundreds of subpoenas I've seen in my own practice as a prosecutor. You write them broadly. You include, as this committee did in its instructions, a provision allowing the recipient to assert a privilege, and you define a privilege as this committee did as withheld from production pursuant to any law, statute, rule, or policy. So in my view, it would have been perfectly appropriate for...
So that subpoena was not asking the Attorney General to break the law?
I don't believe it was. He would have been perfectly within his rights to respond. Here's everything I can give you, but there's this Rule 6E piece that I'm not going to give you, and I'm going to assert that pursuant to your own instructions to him.
Thank you very much. Who's next? The gentleman from North Dakota, Mr. Armstrong, is recognized.
Thank you, Mr. Chairman. And I think sometimes we might not, these aren't always ideological differences. As somebody who practiced criminal defense in both state and federal court for a decade, I have a drastically different impression of subpoenas being issued than prosecutors necessarily do. So we just had that discussion about the subpoena and about Rule 6E. So I would start, because I do think context matters. So I would start with Professor Turley. Do you agree with that back and forth analysis we just heard?
No, I don't. I think it's a mistake to compare subpoenas used in conventional practice with a subpoena issued by a congressional committee. They are different creatures. Yes, subpoenas that are issued in litigation are often too broad. They're often setting the table for fights. This is not some litigant in a state court fighting over a subpoena. You have to tie your requests carefully to your authority to demand information. What I would suggest to my friend is that if Bill Barr had actually complied with the subpoena as written, he would have violated federal law.
Thank
and
you.
this committee also said, by the way, that they believe that Rule 6C did not bar Attorney General Barr from releasing information. I think that's also not true.
Well, and I have 2 points to that too, because I mean, this is a political body for various reasons. So there are a lot of people on both sides of the aisle that have spoken up in print, on TV, and all of those things. And I can tell you that up until the day of the contempt hearing, there's nobody out there saying that 6E information is not supposed to be disclosed. I mean, the narrative and the way this was working was the entire unredacted Mueller report. So I'm just going to do this really quickly. Professor Shaw, if Attorney General Barr would have provided a complete and unredacted report, would he have violated the law?
I mean, I think the law protects grand jury material. Yeah, I would agree with that. Yeah.
Mr. Rosenweig, do you agree with that?
I agree, though I would say that nothing in the statute prevents him from asking a court for permission to provide that Rule 6E material.
I agree with that, but nothing in the statute or our authority compels him to do that. And a subpoena surely doesn't compel him to go to court.
A subpoena surely does not compel him to go to court.
Professor Kinkoff, do you agree with that?
Sure.
Okay. So I think it's important. I mean, this blanket assertion of privilege happened the morning of a contempt hearing. I mean, this protective assertion of privilege happened the morning we were going to hold the Attorney General and Barr in contempt for information that he could not provide in compliance to the subpoena by law. And one of the reasons I bring that up is because we've talked about this. Professor Turley cited, I think the total report is 98.5% is available to certain members. Of the obstruction side, I think it's like 99.9%. And the reason I'm saying this is because when I read all these cases, whether it's Holder or Oversight v. Holder, and we're dealing with all this, a big portion of the analysis is on research or on accommodation and negotiations. And I think Professor Turley talked to it about, the questions about conditional waivers. And so we talk like if the people on this committee who have access to that in a secured setting, like that becomes the end of it. But that's typically where we would start having this negotiation and accommodations. And that's what's happened in prior cases. That's what happened in Holder. That's how we worked our way through this. And I mean, when you have one party controlling one branch of government and one party controlling the other branch of government, there is going to be combat. There is going to be back and forth. There's going to be those. We saw it in the Holder case, and eventually they went to court, and there had been documents provided over the course of months and months and months. But that didn't happen here. And outside of everything else, there was no time for that to happen here. This all happened in a span of, a very, very short period of time. So how do you deal with the negotiation and accommodation part of this after you've held a contempt order on a person who can't comply with your subpoena? And so I'll start with Professor Shaw.
Well, I think the process continues. I think that accommodation can be ongoing today and next week, and that was true before the committee contempt vote, and I think it remains true. So I think that it is incumbent on both this committee and the White House to attempt to, de-escalate if possible. I think it's only possible if there's meaningful attempt to provide information to the committee, which, as I understand it, although I agree that the timeline is short, in some ways, I presume the decision was made that it doesn't matter how much time you give to a party that is providing no information. You may as well proceed quickly to the next stage of negotiation if there is absolutely no cooperation forthcoming.
And I don't necessarily disagree with that. My point would be that there was no cooperation on either side. I mean, we were saying you're providing the whole thing, and he's saying I can't provide the whole thing. And I think that I'm out of time, so I just say that the negotiation and accommodation part would work a lot better if the contempt order wasn't in place. And to quote somebody on the panel from a hearing we had earlier, I think Congress has met the enemy, and sometimes it is us. This was in a different context, but I think we're fully aware of what we're doing, how we're doing it, and why it's not the most effective way to accomplish our goals. Thank you.
Thank you, Mr. Chairman. First of all, thank you to all the witnesses for being here. I think most of you here will agree that executive privilege serves as a vital function in our government's ability to make laws and protect our national interests. Without it, presidents and the privacy required to make decisions of great national interest would be severely limited. Frankly, I don't think any one of us here at the table would want to do that. And unlike some of the statements that have been made by my colleagues across the aisle, we are not here because of animosity to the president. We're not here on the self-described by the president witch hunt. We're really here to get to the bottom of the truth and to take the facts where they lead us. I know for me, as a former judge and a lawyer, there's nothing more important in our country than the rule of law, and that's what we are here fighting about. I want to start first, though, to just kind of dispel some of the comments that have been made across the aisle that somehow they think we're just all sitting here trying to think about impeachment or investigation in some ways to get back at the president, and we're not taking care of business. This committee has already heard and passed the For the People Act, which protects our vote and is about election reform and ending corruption in government. We've already passed a bill about preventing gun violence, protecting Dreamers and TPS recipients, another bill reauthorizing the Violence Against Women's Act. We've also looked at the state of competition in the healthcare markets. We've looked at the history and enforcement of the Voting Rights Act. We looked at the lack of diversity among patent holders. We've looked at the Equality Act protecting the LGBTQ community. We looked at the Equal Rights Amendment, at hate crimes and the rise of white terrorism. We also have been looking at the family separation policy because, yes, there is a crisis at the border, but it was created by this president. We've looked at the National Emergencies Act. We've looked at the proposed Sprint T-Mobile merger and the oversight of the U.S. Patent and Trademark Office. We've been working, but we also don't lose sight of the responsibility that we have under the Constitution, legally and ethically, to have oversight over the actions of this administration. So it really concerns me that some would like to twist what we're trying to do, because frankly, if we don't do it, then who will? And for me, I take that responsibility very, very highly. And Ms. Shaw, I wanted to start with you because you made a comment in your testimony that kind of intrigued me. You said that there may not be a waiver of executive privilege in intra-transfers among the executive branch. What does that actually mean, and how broad is that?
So when the comment is made that the president didn't assert executive privilege to prevent, say, his White House counsel from cooperating with a special counsel, I think there's an open question whether he would even need to assert executive privilege. Instead, he could have just directed his White House counsel not to cooperate. Wouldn't necessarily.
You're talking just about the counsel staff.
Just his immediate staff members or any executive branch official.
Having been in government many years, when you say intra-agency, I just wanted to make sure that the public who's listening, who may not understand the complexities of the bureaucracy, if you will, everything from the White House on down, that you don't mean any agency.
Well, so I think as an intra-executive, right, just within the executive branch, so allowing an executive branch official to talk to another executive branch official.
Does that include Department of Justice lawyers?
Yeah, so that would include.
Does that include the investigators we've talked about earlier?
Yes, I believe so. So I think my point was that talking to all of those categories of individuals who are all executive branch officials of some sort presents different questions than allowing the dissemination to another branch of government of the same information.
Okay, you also say in your written testimony that our third category of requested information in our subpoena is too broad. The committee has offered to narrow its request exactly as you suggest, including in negotiations, and again in its May 10th letter. Do you believe that it's an appropriate accommodation?
Thank you for the opportunity to address that. And yes, I did in my opening statement, or in my written statement, suggest that Category 3 was, in my view, too broad. But I now understand that the committee has, if not, I think it may have actually abandoned its request for documents in that third category in favor of just the documents referenced in the report as opposed to the entire universe of documents. And as to that, I think that that's a perfectly appropriate accommodation. And if I might just comment on the general exchange about the kind of propriety of the breadth of the initial subpoena, my view is that it is quite appropriate in that this is an iterative process, and courts understand that, and all the participants understand that broad requests always get narrowed, and that, in fact, is the whole game. And so I don't think there's anything inappropriate in the face of the subsequent narrowing that this committee has been willing to make in having made an initially broad request.
Okay, thank you.
Thank you.
I yield back. I think I'm out of time, Mr. Chairman.
Before I recognize the next member, I ask unanimous consent to introduce into the record these excerpts from a report by the Project on Government Oversight entitled When Congress Comes Calling, a study on the principles, practices, and pragmatics of legislative inquiry. Without objection, gentleman from California. Mr. McClintock is recognized.
Thank you, Mr. Chairman. Professor Turley, I keep hearing that we're in a constitutional crisis. To my mind, a constitutional crisis is a matter that our constitutional institutions cannot resolve. Is this a crisis, or is this just the normal tension between the executive and legislative branches?
No, it's not a crisis. I mean, there have been serious fights with prior administrations. During the Obama administration, the Clinton administration, there were massive fights.
So what is the constitutional path to resolve this dispute?
Well, I think that all of the witnesses agree on some salient points, but one of them is that this is a process that usually is resolved through a give and take. The one thing I would caution again is this discussion about how the subpoena was drafted. Understand what you're suggesting.
I mean, but would we not take this to court at some point and say, look, the executive thinks one thing, the legislative thinks another, judiciary, please weigh in on this?
Right, but when you go to court with this broad subpoena, you're guaranteeing to lose to some degree.
I get that, but is that we're obviously not taking that path. We haven't gone to court. Right. Why haven't we?
I'm not sure. I think that, quite frankly, the committee pulled the trigger too fast on contempt.
Was it possible that the legislative branch's case is very, very weak? You kind of suggested that.
Well, I have to say, we obviously disagree on this point. I would have thrown myself bodily across the subpoena to keep it from being signed.
But it's been signed. It's all water under the bridge, as they say. But is this not an impasse that ultimately would either be resolved by negotiations between the two sides or by recourse to the judiciary?
Well, usually this would be resolved on both sides. The question is, by pulling that trigger on contempt, did you actually interrupt the process? Because now you've sort of forced this into a formal court proceeding. And
I understand that, but my point is
out.
there are institutional ways of dealing with this impasse.
Right.
All right. On the protective assertion of executive privilege, my understanding is this is simply the executive branch saying, wait a second, you guys have just asked for 1.4 million pages of material. Some of that is illegal for us to release. Some of it would interfere with ongoing investigations. We don't know which until we go through each one of those 1.4 million pages. So we're gonna put a protective order on all of it as we go through that, and we'll release what we can.
That's right. This is why I hate to come back to the way the subpoena was drafted. If you take that to court, that's why you're guaranteeing that you will lose to some degree. Now, people have said, well, this is just a conversation. We go overbroad, then we get something.
I think that's why we're making all of this fuss and fury rather than going to the court, because I think deep down inside our folks know this is an extremely weak case.
Well, but what a court would have to say is that, look, a subpoena is a demand for information. You're saying you must turn over this information. A subpoena is not some casual form of conversation to concentrate the mind.
If we thought we had a strong case, we'd be in court in a New York minute.
Right, and I think ultimately this committee will prevail on getting some of this information under the subpoena. I think this committee has an unassailable and compelling right to some of this information.
Well, again, if the administration had released material protected under 6E or released material involving ongoing investigations, you know for a fact that in a heartbeat there would be a criminal referral against the administration either for releasing grand jury testimony and violating 6E or obstructing justice by releasing material of an ongoing criminal investigation.
Well, one of the things I said earlier is that the reason I think this committee should shift from or pivot from the redactions is I think you're guaranteed to lose some of that fight and create precedent against yourself. But more importantly, if the court just agrees on Rule 6C and ongoing investigation, that's virtually all the redactions in the report. The report itself is only 8% redacted. So you're going to a court, and the court is going to look at you like, really? You're going to fight on this ground. Where you have a really strong argument is on those witnesses and the supporting material. But on that, I think a court is going to view this committee as premature when it pulled that trigger.
Why is it illegal to release grand jury testimony?
Why
is it illegal to release grand jury testimony?
As the D.C. Circuit said recently, the 6C rule that this body helped draft understands that in grand juries, a great deal of information is brought in that is highly damaging to individuals' reputations. It is not subject to cross-examination. So when I have had clients go into the grand jury room, I stand outside, and my client has to say, I want to go talk to my counsel, and they have to leave the grand jury room. Otherwise, everything can go into that grand jury, and there's very few rules limiting the prosecutors.
Thank you. Gentleman's time has expired. Gentleman from Maryland, Mr. Raskin.
Mr. Chairman, thank you very much. Mr. Rosenzweig, I don't know whether you saw this exchange yesterday that took place between U.S. District Court Judge Amit Mehta and the president's lawyer, William Consovoy, but I just want to read you a little passage and then get your reaction to it. The Judge Mehta said, President Trump's finances are not subject to investigation. Correct, Consovoy said. Congress can't verify the accuracy of the president's financial statements. Correct. The judge says, if a president was involved in some corrupt enterprise, you mean to tell me because he is the president of the United States, Congress would not have the power to investigate? No, Consovoy said, because that's not pursuant to its legislative agenda. So, starting with presidential finances, is there any reason to believe the president's lawyer that Congress cannot investigate the finances of the president?
I believe that Mr. Consovoy's statement is wrong, and not just wrong, but frivolously wrong.
And what about his suggestion that Congress could not investigate criminal activity or corruption in the executive branch or on the part of the president?
That would be contrary to more than 220 years of congressional precedent dating back to the first investigation of military disaster under President George Washington.
Thank you. Professor Shaw, there's a increasing pattern now of the executive branch asserting that this body has no proper legislative basis for its inquiries for information. In your experience in the executive branch, was it normal practice for the government to respond to oversight requests by saying, what's it to you? What does it matter? What is your proper basis for asking this question?
Not at all, Congressman, no.
In other words, it has been the standard practice of Congress in the executive branch for centuries, really, for Congress to be able to exercise its broad and comprehensive oversight power by asking for information from the executive branch, and the executive branch just complying, however happily or unhappily.
I certainly think there is resistance at times, but I think that the general narrative has been one of, maybe I could call it grudging compliance, but recognition of the legitimacy of the requests.
Yeah, Professor Kinkoff, do you believe that the executive branch should be refusing to produce information based on the assertion that Congress really shouldn't be asking for it?
No.
What about the claim that moves some people that there are political motives? I know when the tables were turned and the Republicans ran these committees, we would often say there were political motives for the Hillary Clinton email investigation, for the Fast and Furious investigation, for the Benghazi investigation, but did that stop the executive branch from overwhelmingly complying with the requests?
It did not, no. Of course there are political motives involved and involved on both sides, and the Supreme Court itself has said that that is completely irrelevant.
The existence of political motives, which is just in human nature and the nature of a representative democratic system, are completely irrelevant to what our constitutional powers are.
Correct.
Okay. How do you feel about the assertion made yesterday by President Trump's private attorney that Congress has no business investigating whether the president has broken the law?
His view is preposterous. Right? There aren't words for what a frivolous assertion that was. It ignores the necessary and proper clause fundamentally, which gives this body the authority to enact all laws that are necessary and proper for carrying into execution all of the powers of the government, including those that are vested exclusively in the president.
I did a little Westlaw search last night. I could not find a single appellate case in the last century where a court has found that Congress has exceeded its legislative authority under the necessary and proper clause and other parts of the Constitution by issuing a subpoena. Are any of you aware of an appellate case in the last century, or even beyond that, where a court has struck down a subpoena as being?
Well, yeah, the Senate Select Committee versus Nixon, D.C. Circuit in 1974 rejected the subpoena demand under oversight authority. Made a distinction between this committee proceeding under impeachment as opposed to oversight, but I would cite that opinion.
Okay.
Can I respond
yes,
quickly to
Professor
that?
Shaw.
I would just say that I think that at least part of the basis of that decision doesn't lie just in the distinction between impeachment and oversight, but lay in the duplicative nature of the request, right? The court says the House Judiciary Committee, right, happened to be, and maybe not just happened to be, was, in a constitutionally relevant sense pursuing impeachment, but that the Senate committee had no legitimate basis to have two committees essentially examining the same material. So I don't view that decision as resting so thoroughly on the, impeachment oversight.
It was based on the redundancy of the request.
That's, I think, a fair way to read the opinion. Yeah.
Can I just make one point?
Unfortunately, I'm down to 30 seconds, or 13 seconds now, so forgive me, Professor Turley. Does anyone here believe the assertion that the executive branch is somehow above Congress's power of inquiry and investigation? Does anybody believe that?
Well, it can be if executive privilege assertions are valid. I mean, executive privilege assertions, when valid, prevent the Congress.
Okay, but in general, what we're getting today is a statement by the executive branch that it doesn't have to participate at all. I mean, is anybody aware of any precedent? Let me come to you, Mr. Rosenberg. Are you aware of any precedent for the President of the United States telling the executive branch not to cooperate with legislative inquiries, saying no more subpoenas, enough is enough?
Not in the wholesale manner here. Professor Turley is correct that some of the means by which the investigation proceeds may be subject to certain privilege claims that are narrow in focus, but I've never been aware of the executive branch being able to tell the legislative that that is not a fit subject for you to be inquiring into vel non.
Thank you very much. I yield back.
I thank the gentleman for yielding. The gentlelady from Arizona, Ms. Lesko, is recognized.
Thank you, Mr. Chairman. My question is going to be for Professor Turley, and I'm just going to give a little bit of background first. Last week, this committee held a business meeting to discuss holding the Attorney General of the United States in contempt of Congress. At this meeting, Chairman Nadler acknowledged a difference between the intent of the subpoena and the language in the actual subpoena itself, which we discussed quite thoroughly at that time. During a discussion about grand jury 6E material, which would require the Attorney General to break the law in order to produce to the committee, the chairman stated, and I quote, "The reason that was in the subpoena was to increase our clout in court in getting the 6E material, hopefully with the Attorney General's support, but it is in no way meant to force him to give that support." So my question for you, Professor Turley, from that statement, do you believe it's safe to assume that the chairman's goal all along was to go to court and not engage in the accommodation negotiation process, and he went so fast with his subpoena, which included 6E material?
Well, I don't want to venture to guess about the chairman's motivations, but what I will say is that I believe it is a mistake, if this is a serious effort to go to court, to put in a subpoena, a demand for information that, if complied with, would have violated federal law. And you're going to a federal court, which tends to be highly protective over grand jury material. They're the last group of people that will take this casual approach to Rule 6E. So what you have is, if that subpoena goes to court, you will start out very likely with creating precedent against yourself and being very clear for all future committees that you don't have this ability. That's the reason I think that subpoena should have been more narrowly tailored. Can I make one statement with regard to my colleague's statement about the earlier case? With regard to the Senate Select Committee versus Nixon, as I say in my testimony, they do refer to the duplicative aspect of the two committees. That is not the holding of the case in my view. First of all, it would be bizarre in my view if the federal court said you have authority to this information, but because those guys got it, I'm not going to give it to you. I mean, I don't know of any case where that would be true. What the court was saying was that you're proceeding under oversight. Those people are proceeding under impeachment. They have the material. And by the way, your case for this information is even weaker because Congress has it on the impeachment side. And by the way, it's going to be coming to you if they end up impeaching. That's what I believe the court was saying.
Thank you. And Mr. Turley, I have 2 minutes left. And so is there anything else you wanted to add to this discussion today that you haven't said already?
Bless you for that question. The answer is yes, and it is this. We have to distinguish between what is being discussed here in terms of waiver. I believe that at least Professor Shaw and I agree that there is not a waiver that took place because of the sharing of information between the special counsel and the White House. That position has been stated by members of this committee, and that's the position that I beseech you not to make in federal court, because you will create precedent against this body. The question of waiver then gets a little more difficult when you talk about disclosures to counsel, private counsel. I think the president has made a mistake by mixing people with different representational statuses and not creating walls. But once again, I encourage you not to push that envelope, because my guess is that it would create new precedent and you wouldn't like it in terms of future investigations. So what does that leave this committee? It leaves the committee with a lot. You can fight and get these witnesses. I think the White House cannot maintain that position. You can fight and get these documents. I don't believe they can sustain that position. But you will have to hone your targets a little more closely to protect precedent. And I'll simply repeat once again, beware of close calls. This is not a blackjack game at Vegas. If you do a close call, that's where you lose precedent, and you have an obligation to future judiciary committees, just as they had an obligation to you. And I suggest don't get into fights that are close calls. You have takedown cases here to bring into court. Focus on those.
The gentlelady from Washington, Ms. Jayapal, is recognized.
Thank you, Mr. Chairman, and thank you all. I think this has been a really instructive hearing. We were sworn to a constitutional duty to conduct oversight of the executive branch, along with many other things, and there are many ways to do this: holding hearings, requesting documents, issuing subpoenas, and holding people in contempt when our requests are ignored. There are over 20 investigations into Donald Trump's actions where the Trump administration has stonewalled our pursuit of the truth on behalf of the American people, and we've talked about a few of them. We went through all these steps to obtain the unredacted Mueller report, which contains information that's vital to protect our elections and ensure that the president isn't using his power to cover up certain things that he's doing. The president responded with a blanket proactive assertion of privilege over the entirety of the report and its underlying materials. We asked for Trump's tax returns, essential for the public to understand whether the president has complied with the law and paid his taxes in full, and to understand any financial conflicts that the president might have. Trump administration said no. We asked for documents to understand alleged abuses into the White House security clearance system, abuses that may undermine our national security. Trump administration said no. I could go on. There's a list of 20 of them. But let me turn to you, Mr. Rosenzweig, because as a career prosecutor, you were independent counsel for the Office of Independent Counsel under Ken Starr, not typically the witness that the Democratic majority would call. You're an expert on executive privilege. And in your written testimony, you explain that executive privilege can't be looked at, and you use the word vacuum, in a vacuum. Given President Trump's pattern of defying as many as 20 different efforts to examine his own conduct, would you agree that the president's invocation of executive privilege has been undertaken in bad faith?
It certainly is a conclusion. As I would be reluctant to impute a motive to the president who I don't know, but it certainly is a conclusion that you could reasonably draw, either of bad faith or a motive of delay.
And in fact, I think in your written testimony, you do say that the president's, it suggests that the president's resistance, you didn't say for sure, but you said it suggests that it was taken in bad faith. Given the competing interests here, including Congress's need to protect our elections, do you think that the blanket assertion of executive privilege by the White House in response to our subpoena is legally justified?
It does not seem to be, and I think one of the reasons that I reached that conclusion is because of the context that you laid out in the premise to your question, which is that this particular invocation, whatever its merits or demerits on its own face, comes in the context of what appears to be a wholesale determination not to cooperate with any congressional investigation. That certainly colors for me an assessment of the validity of the invocation and also ought to color your assessment of it as well. And I think, frankly, would color a court's assessment, too.
Yeah. Thank you. Professor Kinkoff, you, in your response to Representative Bass, said, never before has there been a blanket assertion that an administration will stonewall all subpoenas and all requests for documents. When I think of a word to describe that, the only one that comes to mind is contemptuous. And just because there's a lot of people watching this who are not legal scholars, don't necessarily understand executive privilege, what is the impact for the average American of one branch of government being completely contemptuous, to use your word, of another branch of government's power? What does it mean for their health care? What does it mean for their life if that is the case?
So Congress is the linchpin of our constitutional system. And to stonewall Congress prevents it from performing its proper constitutional role. And that puts everything in jeopardy. And you're quite right to bring it down to that sort of kitchen table level of our health insurance, of everything else that we rely on and are engaged with every day, because it does filter down to that level.
It's not some distant thing. It is actually the idea that we have no oversight or authority over another branch's actions, even when they're unlawful. So do you think that the actions of President Trump and Attorney General Barr in refusing to respond to any congressional subpoenas are permitted under the Constitution?
No.
Thank you. You have a footnote in your testimony where you say in this connection, the president's recent declaration of a blanket intention to oppose all the subpoenas is unprecedented, contrary to the process that the courts have regarded. So this issue goes beyond partisan politics. It is about our democracy, our Constitution. It is about precedent that we set, of course, and it is about us being able to do our constitutional duties and to have checks and balances. And I see that my time has expired, and I thank you, Mr. Chairman. I yield back.
Thank the gentlelady for yielding. I now recognize the gentleman from California, Mr. Correa.
Thank you, Mr. Chairman. I want to thank the witnesses for being here today. You're appreciated. I want to say, as a member of Congress, as a member of this committee, I take my job of oversight over a co-equal branch of government very seriously. So I thank you for being here for your testimony. Talking about balance, reasonableness, time to respond. Professor Kinkoff, I want to ask you if you think the Attorney General can legitimately claim he needs more time to conduct a review, given that the committee itself made it clear for several months that we had a compelling need to review the unredacted documents and reports of the underlying evidence.
With respect to the unredacted documents, or the unredacted Mueller report, I think the claim of a need for more time is just not credible. As to the underlying documents, though, I think it's fair, but only for a very brief window of time. And I point this out in my statement. The precedent for this is the 1996 protective assertion by Attorney General Janet Reno, and a full response with privilege logs specifically identifying what documents are privileged and why each document is privileged was forthcoming 2 weeks later.
You know, we offered in a May 3rd letter, as well as in the April 18th subpoena itself, to prioritize specific defined set of underlying evidence. We essentially said, prioritize which information you could present to us and what other information you need time to present to us. What do you think about that information? Did that change your response?
Well, I think still it's fair for the executive branch to say we need time to look through and see what's privileged and what isn't. I do think, though, it bears on this question of whether or not you've simply issued a subpoena and then moments later issue a contempt citation.
Professor Kinkoff, Attorney General Barr's letter to President Trump said protective assertion was consistent with something that had been done during the Clinton administration. But in that case, about 2 weeks after making the protective assertion of privilege, the Clinton White House completed its review and released 1,000 pages of documents and produced a privilege log as to the documents it withheld. Should we expect the Trump administration to do the same thing here?
Yes, I think the Trump administration should be held to the same standard. I'm not sure that I would say you should expect the Trump administration to do that, though.
Well, the point here is that we've gone through this exercise before. The administration under Clinton released 1,000 pages on a timely basis and then gave us a log of the information that they were not releasing.
Right. I think the point here is that the idea of a protective assertion of privilege is basically an expression of exigency, as we don't have time. And it's justified only as long as that exigency actually exists. So yes, the administration might say 1.4 million documents is going to take us a bit of time to go through, but the Justice Department has lots of lawyers, and it can go through even that large a document request very, very quickly. And it is its duty to do exactly that. It is not a proper mechanism for merely delaying and deferring the committee's request.
For the people of this country watching this hearing today, what is a protective assertion?
A protective assertion is an assertion that we believe there are privileged documents within the many boxes that you've requested, but we need some time to go through and pick out the privileged documents, right, to pick them out and in order to release those that aren't privileged.
And do you believe this committee's offer to work with the administration to give them time to prioritize the documents to be released in their terms, is that something that's reasonable, that a court would look at and say, Congress is being reasonable, they're being fair with the administration?
Yes.
Thank you very much.
Does the gentleman yield?
Yes.
Thank you. I have one question for Professor Kinkoff. Professor Turley suggested that we don't have a narrowly tailored purpose for our subpoena. In Professor Turley's written testimony, he acknowledges that where Congress has a strong legislative purpose, that is a factor in assessing executive privilege, but somehow suggests that our investigation into alleged corruption, obstruction, and abuse of power is not sufficiently tied to any legislative purpose. Do you agree with Professor Turley's apparent position that this committee does not have a valid legislative or oversight purpose in the subpoenaed information?
No, I do not. I couldn't disagree more strongly. As I point out in my written statement and as I mentioned in my opening statement, I think Congress has a compelling interest in knowing all the details of Russian interference in the 2016 election in order to be able to legislate intelligently on how to fix the system. I believe that this committee and Congress also have a compelling interest in investigating serious and substantiated allegations of presidential misconduct. And so those interests more than justify your request for those documents, and I think then impose on the executive branch a duty to say with specificity why each document it wishes to withhold is privileged and is privileged in a way that cannot allow an accommodation of your compelling interests.
In fairness, can I respond to you, Mr. Chairman?
Sure.
That is not my testimony. I say in my testimony that, in fact, I believe I go through each of the elements of Wilkinson, the three elements, including purpose, and I say that you have satisfied the Wilkins condition for purpose, and I do not believe you would lose on that ground. I say that quite clearly in my testimony.
Well, thank you for clarifying that very much. I thank the gentleman for yielding to me. Does the gentleman have anything further to say?
Further comments, Mr. Chairman.
Thank you. The gentleman yields back. This concludes today's hearing. I want to thank our distinguished witnesses for attending. Without objection, all members will have 5 legislative days to submit additional written questions for the witnesses or additional materials for the record. Without objection, the hearing is adjourned.